Friday. But the main reason the matter did not list, my lord. So I pray for to be listed tomorrow. It may be dropped also by mistake. Tomorrow.
My lord, I beg to mention for urgent motion matter, either today or tomorrow.
Subject,
Subject is a land requisition. They have requisition, but without issuing any order or notice in that regard. Without issuing any order in that regard, and they are started construction in the middle of the entire 3 bighas of land, and they have requisition 9.5 lesses only. I have annexed the photographs. They are in the middle of the plot of land. They have started construction by digging the earth and all.
okay, try to bring it today.
Well, obliged.
May it please your lordship. Lordship, I beg to mention item number 12, your lord. Can it be possible for the day, your lordship?
Okay.
Obliged, your lordship.
On the prayer of Mr. I. Hussain, learned counsel for the petitioner, the case is possible for the day. MS as Bural and Junior Advocate Assam for the state respondents. It's present.
May I please your lordship? My lord, I beg to mention item number 22, my lord.
Yeah.
It may be taken up after vacation because the state has not yet been filed any.
Mr. S.K. Ghosh, learned counsel for the petitioner, has sought for listing of the case after the ensuing winter vacation. The prayer is allowed, list the case after the ensuing winter vacation on a date to be fixed by the office.
No, sir.
May it please your lordship. I want to pray before your lordship for listing a new matter, my lord, regarding settlement of a repairing work, my lord. Earlier matter, the
Settlement of?
settlement for repairing and renovation work, my lord. That was earlier issued in favor of the, decided in favor of the petitioner. Subsequently, without knowledge of the petitioner, my lord, it has been settled in other person's favor, my lord.
What kind of repairing?
My lord, national NHM, National Health Mission construction of laboratory.
Tender matter, Wensport.
My lord, I beg to mention a matter for listing tomorrow. It concerns, my lord, there's been a direction to change the nomenclature of a cooperative society, your lordship. But that will have an adverse impact on the investors, your lordship. There are about 1 lakh investors. So without taking them into confidence, my lord, if the nomenclature is changed, it may create a chaotic situation, your lordship. So
What kind of entity?
it is a financial organization. It uses the term bank, your lordship. So there is a direction that the term bank be removed. So now, earlier also, your lordship, in principle, approval of the RBI had been withdrawn. There, some of the employees had to commit suicide, your lordship. So now also, tomorrow, if this is withdrawn, then also it may create some kind of a chaotic situation.
Let it be after vacation.
Lordship, tomorrow, kindly just.
Let it be. That is no change of nomenclature when it was directed.
Lordship, it was earlier directed. We had filed it on 4th of December, your lordship.
We did not, sir. We just
4th of December. Then I did not have urgency till today.
Lordship, but
You did not have any urgency till
What
today.
happened
4th of December, you have filed.
your lordship, what
No,
happened?
no.
The tenure
3rd
of the
3rd of January.
lordship, the tenure of the board of directors had elapsed. Then there was a
Mr.
direction to-
Day, you filed a petition on 4th of December.
कोड नंबर क्या है?
No, actually, they said that the
3rd of January.
board of directors.
You did not have any urgency till today after filing it.
Lordship, we kindly consider tomorrow, your lordship.
No.
Lordship, there's another matter. This concerns, your lordship, the enhancement of rent of certain shops under a municipal board, Kolkata Municipal Board, your lordship. So notices have been issued that by 25th, if they are not paid this rent arrears of rent, then their allotments would be cancelled, your lordship.
Okay.
Tomorrow. Much obliged.
Bring it today.
Tomorrow, your lordship.
You have not filed.
No, we
That
have
means-
filed it. We filed it. Filing number is 15791.
Okay, bring it today.
Much obliged.
May I please, lordship? I beg to mention for listing at WBC. it was last listed on 6/12 lordship. There was a stay order for not evicting my house lordship, but last yesterday the respondent authority evicted my house lordship. They destroy our house
Already evicted.
already.
Then there should be contempt.
Lordship, the front part of house they evict.
Okay. New matter.
Not new matter, it was matter 2017, from 2017.
Okay.
Tomorrow lordship at 2.
Not at 2. Before 2.
Alright.
Daily list for motion, item number 1.
Yes, what contempt?
Herein, your lordship, case 14 is the order, your lordship. Page 14 and page 16 is the relevant. Para 7, your lordship.
Heard Mr. M. Khan, Learned Counsel for the petition. The petitioner has preferred the instant contempt petition, alleging non-compliance of the direction contained in an order dated 10/4/2023, passed in a writ petition, WPC number 2116/2021. Issuance returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondents by registered post immediately within 3 working days.
2, item number 2.
2 is also same, your lordship. And order is page 14. And 17 is the relevant point.
You have, let me see. You have served a copy only to Deputy Commissioner.
Direction was only to serve the deputy commissioner. Thereafter,
Then why one? Then
and thereafter the
why one then? You have not served any copy.
the direction was to serve the copy to the deputy commissioner. Thereafter, the deputy commissioner will verify and send the report to the contempt number 1 for disbursement of amount. Page 17, your lordship, and 10, your lordship kind.
Same liquidity. Order 1/2/2023, WBC 4054/2021.
Item number 3.
Miller, this is contempt application, Miller. Honorable court order at page 11, Miller.
Mr.
Take care.
Azhar. Order dated 24/7/2023. WBC 972/2023.
Item number 4.
My lord, item number 4 is also same.
एक ही आधा 24/7/2023 order. Notice, WBC 9/68/2023.
Item number 5,
Well, here I have got the instruction. So I prefer some time to file the affidavit, and it should be listed in the admission column. my lord.
Oh, notice has already been issued.
Yes.
They were directed to file the affidavit by the last
Mr.
order. Yes, Mr. Lordship.
S. Mitro. And Mr. S. Mitro, Learned Counsel for Application, and Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department. For all the respondents.
All responded.
The Learned Counsel for the parties have submitted that notice has already been issued on 13/9/2023. And as such, the case ought to have been listed in the admission column. Be that as it may, Mr. Gogoi, Learned Standing Counsel, Finance and Taxation Department, appearing for the respondents has sought for
But 3 weeks time to file affidavit.
and is granted 3 weeks time to file counter affidavit on behalf of the respondents. Release the case after 3 weeks on it will be fixed by the office.
6,
Item 6.
6.
My lord, this matter pertains to, my lord, issuance of occupancy certificate. Now, there is already a litigation, my lord. There is already litigation and petition has been filed with regard to, my lord, the building, my lord. The only thing at this stage, my lord, I pray that my notice may be issued, my lord.
Oh, that can, it will.
One, Mr. Gautam Baba, he filed WPC 4389 of
Come to
2000.
the impugn order.
Yes, impugn order is, my lord, page.
Last paragraph.
Yes, last matter, page 18, sorry, annexure 18.
Why notice should be issued? 137.
Yes,
137.
yes, this is, my lord, actually, my lord, this impugn order has been issued. NOC was given for block A, B, and C.
Come to page 138.
Mm.
Therefore,
Yes. Therefore, the builder is directed to furnish revised occupancy certificate proposal on the basis of the revised plot area and revised existing access from the secondary road and based on applicable norms. Further, the landowners are directed to furnish proposal for regularization of the existing G+2 and Block C in pursuance to the order of the Honorable Court dated 28/9/2022 in WPC 4389 of 2020. Both these proposals of occupancy certificate on revised parameters and regularization proposal of Block C and existing G+2 building shall be dealt by this authority as per provisions of the master plan and building by plan bylaws as applicable, subjected to NOC from the other flat owners as per provisions of real estate regulation development. Act.
so builder has been asked to submit revised proposal.
Right.
So if builder does not submit, the case comes under
Under this,
for
real,
for the flat owners.
right. Now, my lord.
You approach the trader if the builder
No.
is not submitting,
No,
because he said it will be that the proposal for occupancy certificate on revised parameter shall be dealt by this authority as per provisions of master plan and building bylaws as applicable, subject to NOC from other flat owners as per the provisions of Real Estate Regulation Development Act.
no. Before that, my lord, lordship will see page 1412, my lord, page this particular plot, my lord. What happened?
Come to Mr. Annexus 16, page 130.
137.
And before that, show cause notice.
Show cause notice. Show cause notice is at, my lord, page
To whom it was served?
It was to the builder, my lord.
No.
Yes,
Address to
proposed
whom?
notice.
Everybody.
Page
The
one
President
thirty-three,
Secretary Nirupama Nivas Welfare
Yes.
Society,
133 page,
133.
133. No, I just give the,
Had you responded it to it?
no, this, my lord, this has been to the.
1, 2, 3, 4, no?
This is the owner of the land, my lord, and the
Okay,
builder.
come to 3.
3 is the president secretary, Nirupama. The society is not doing anything, my lord. That's why few flat owners had come before this honorable court.
Then whether
No,
whether that forum is adequate forum or not.
no, lordship, before that, my lord. That's what I want to say, my lord. When NOC was granted, lordship may see that NOC, my lord, granted, that is in respect of block A, block B, and block C.
That order is not to your prejudice
No,
as of now.
no, I'm saying that, my lord. Lordship may see, page 137 for a moment, my lord. Whereas, to the opening portion of the letter, my lord, page 137. Whereas NOC for 3 apartment blocks A, B, and C, NOC was issued for 3 blocks, my lord, together. Now, my lord, the GMD is saying that block A, B will be a separate occupancy certificate and block C will be a separate. I'm agreed with that, my lord.
How you are agreed?
Because, my lord, there is no bifurcation, first of all, block A, B, and C. It is all together NOC was applied for. So, my lord, if it is separated, my lord, then it will become 2 portion, my lord, where I have to take, my FIR will be reduced, my lord.
Now, this order is appealable or not?
But so far, my lord, appealable, so far, issuance of occupancy certificate,
An order passed under perhaps 87?
87, 88, my lord.
Yes, MS Shutia. Is it appealable or not? Yesterday, I have found that there is in a similar case, I have disposed of because both the parties preferred appeal before the appellate authority. What is the appellate authority?
District.
See, if there is an appellate authority in place,
No,
because yesterday it is a district judge.
lordship,
On same 87, Mr.
No,
Roy,
I understand, my lord.
we do not want to open the
Very good. But, my lord,
two forums are available.
Right.
If you are aggrieved by the action of the builder not submitting a revised proposal, then it is RERA. And if you are aggrieved by this order, and if an appellate authority is available under the act, have you examined that or not?
no, I will examine, my lord. One thing, my lord, because there is already a repetition pending where the Honorable Justice, my lord, passed an order which is there, my lord, on 18/11/2022, page
You do not want
139.
to add to the numbers.
At 139. Only one, my thing is that, my lord, whether GMD authority is correct in, my lord,
Are you a
bifurcating.
member of that society or not?
I am the member of the society.
Then,
Society is not coming, one, even
even then, let us see GMDA. Yes. Where is Mr. Nayak?
Another court file. After some time.
Nayak also appeared in early litigation, my lord.
That is a different litigation. Here, this litigation has amended from page 137.
Yes, very correct, my lord. Very correct. Very good. 137, my lord.
There are 2 parts to it. Last paragraph.
Yes,
Suppose
2 parts, my lord.
builder has been given the option, right, for occupancy certificate to submit a revised proposal. And they have not closed the door. They have said proposal will be considered as per law. That is one part. If builder does not do anything, the flat owners have the option against him under the RERA,
Yeah.
right? And if you are totally agree, otherwise notices were issued to you. Now you have
Lordship may,
come out of that society.
Lordship may say 146, man, for a moment, man.
We'll see. Then if this is an appellate order, appeal lies under the statute, then we are not opening the
Lordship may see page
read forum for you.
146.
146 of what?
146 of the writ petition.
You are agree by, tell me, you are agree by what?
But I'm agreed by the GMD's action.
Bifurcation of A plus
A,
B
B,
from C.
C, my lord. That is because NOC was issued for A, B, and C together.
How, why you are agreed?
Because my lord, if I have to take occupancy certificate, if the apply for the builder, then the FR will be reduced, my lord, because AB will be the entire plot of land will not be schedule A, that which is said. The schedule will not be considered. It will be two part portion will be considered, my lord. That's what I'm agreed, my lord. If
How, your flat is going to be demolished?
yeah, it may be, my lord, because fourth floor up to this is seventh floor is illegally constructed, and that
You are not occupying 7
no, I'm not occupying seventh floor. But because of that, occupancy certificate has been rejected. my lord.
Yes, this, any order that is available or not. Yesterday I have found that there is a statutory remedy. They, parties have submitted. And they were maintaining parallel proceedings. Which we not encourage. এখন GMD নাকি? GMD কোড আছে এটা? What is the original notice? It is not that you had not been given the opportunity to respond to the notice.
No, my lord,
Notices were served upon you.
no, my it was up to the builder, my lord.
No, no. President Secretary, who is Nirupama Nivas Welfare Society? Come to page 133.
It is the president, secretary, and you.
Have you explained in the writ petition
No, my lord.
why you have got yourself separated from the society?
Of course. They're not taking steps. That's why, my lord, we came, my lord.
No, have you stated so? Oh, পুরনি। Yes, what is the appellate provision? Yesterday you were there. Is it not? You were not there. Who were there? For GMDA? I forgot.
I think,
The petitioner, respondent both submitted that they are pursuing appellate remedy. And GMDA council has also submitted that there is an appellate provision. As three councils submitted, three sides submitted, I acted on that.
But I,
That district judge is the appellate authority. All of them have submitted.
let, madam, I
Already
pray that,
item
madam,
number
let
14.
notice be issued, my lord.
Item number 14 is-
Let them respond. And, my lord, only thing is that.
Why should I issue
No,
notice?
lordship will see, my lord, that whether JMDA was right in holding two parts of the property, my lord. When NOC was issued for the entire matter A, B, and C, my lord. That is the only thing your lordship will look into.
No, when an appellate authority who can definitely go
Because
into
already,
that
there
aspect,
is a,
why should we enter in it?
my question is that there is already litigation pending and, my lord,
That does not give you a license to enter, maintain another repetition.
lordship,
Section 71 of the GMDI. It's before the district judge and it is the final, that order passed by the final. 71.
Section 71. And the district judge has been appointed already.
This page has been, then notification is.
Examine this.
I will examine this. Let it come, my lord,
Because,
Petition, my lord.
yes, one chapter has been devoted for,
I'll see.
one chapter has been devoted.
I'll look into it. Let it be after vacation.
Because a read petition cannot be maintained as a matter of course. You have to satisfy.
I'll,
Can I leave my lord? Lordship will record the name of PIN because I cannot appear in this case, my lord.
Right. No. Because I was asking MS.
I cannot appear because I have filed the petition, this order has been issued. When I was not the student council.
No issue. I'll record as Shutia's names. You examine this provision.
my right,
One chapter has been devoted.
but I'll check.
And as I think bring the notification also appointing district judge as the appellate authority. Yes, J. Roy, Lioness Senior Counsel. Assisted by MS, NM, M, Lioness Counsel for the petitioners, and MS Air Chutia, Lioness Counsel representing. As ZDD,
Madam.
Mr. P. Nayak, Standing Counsel, ZDD. And GMD. And GMC?
Madam.
Is GMC also? GMC. For the respondent number 1 to 7. So stop. As an appellate remedy is also under section 71 of the GMD Act 1985 is also available. Is available. Come on. Mr. Roy has sought time to complete his instructions, lays the case on
18 January, my lord.
18. There is a chapter
I'll see that.
now because yesterday it was submitted and today I have seen.
Right, my lord, but only thing is that, my lord, I am agreed with like page 146, my lord. That GMDA bifurcating, but that ultimately that issue will come, my lord. When you issue the NOC for block A, block B, C, how can you bifurcate A, B one part and C one part?
Yes, that is clearly within the province of the appellate authority.
We'll see that, my lord.
Absolutely. Absolute power has been given to the appellate authority. And he is not a, he is a judicial forum. It is a judicial forum. Examine
I'll
that.
see that.
Item number 7.
May it please your lordships. May it please your lordships.
Yes.
I beg to appear for the petitioner, my lords. Lordship, this is a petition which challenges the inaction on part of the state VAT authorities in not sanctioning my refund, my lords, my application is pending since April 2005 for the assessment year 93-94, my lords. We have written several communications and reminders to them since 2017
Okay,
till
I will have the instruction, only refund, madam. Nothing. Only refund, prayer is for refund of the
What is the provision?
Lordship, this is under the provisions of the Assam VAT Act,
Then Assam General Tax Act.
Section 50. madam.
Lordships.
Section 50.
Assam?
Assam Railway Tax Act 2003.
VAT Act, my lords, the VAT Act, Value Added Tax Act. They have passed
Let me have
assessment
a glance at the book.
Well,
I have not read the provision. Your claim, last claim is of the financial year 1998-1999.
Lordships.
and there is a limitation also, madam. Rule 29.
You made the demand, claim.
Yes, my lords, I have made the claim. The claim has been filed on April 2005, my lords. There are acknowledgements evidencing the claim of my refund application, my lords. Post that, they have passed assessment year orders for three assessment years, my lords, and they have sanctioned the refund. I am unable to understand
When it was sanctioned?
That was sanctioned, my lords, in the year 2017, October 2017, my lords. And those orders I have annexed at Annexure F, my lords. There are 3 orders for 94, 95, 96, 97, and 97, 98.
And what is the rule, Mr. Gogoi?
My lord, Rule 29. It is flag mark already, madam. Yellow flag mark, madam. It's there at the top.
Okay, where is the sanction order?
Lordship, there are 3 sanction orders for 3
Yes.
assessment years. That is 94, 95. Then 95, 96, there is no order for which I am seeking an order. 96, 97, there is an order. 97, 98, there is an order. 98, 99, there is no order for which I am seeking an order. That is at Annexure F onwards, my lords. Where
No,
they have sanctioned.
in your prayer, it is 93, 94.
Lordships, 93, 94.
Tell me about 93, 94. Where is the sanction order?
No, my lords, 93, 94, there is no sanction order. That's my prayer.
Then why did not you make any claim?
We have made a claim, my lord. My claim is as old as 2005. They have not even responded, my lords. They have not even answered to several communications.
Then why you waited for 18 years?
No, my lords. What has happened is, subsequently, when they sanctioned this refund for 3 years, that was in 2017.
Where is the sanction?
Lordship, that is at Annexure F.
Page.
Page, my lord. Lordship, may kindly help me.
53, my lord.
Page 53 onwards, my lords, page 53 onwards. These are three assessment years, that is 94-95, 96-97, and 97-98. Page 53 onwards, has my lord got that?
Mr. Counsel,
Lordships.
94-95.
Lordships.
Order, sanction order, page 53
Lordships.
is for 94-95.
Page 53 is for the financial year 94-95, my lords.
Now, your prayer does not equal 94-95.
No, my lord, this they have sanctioned. My prayer is that only for 3 years you have sanctioned. For 3 years, why are you not sanctioning? I have been begging since 2017 and I have written n number of letters to them. Not a single letter is being replied. I am unable to understand, Manoj, why they cannot reply. Why should I
You
come
mean
your
to say for some years it has been sanctioned
Lordships?
and for some years no sanction has been accorded?
Lordships.
That is your case.
Lordships.
Heard, Mr.
Bharat Raichandani, Lordships.
B. Raichandani, Learned Counsel for the petition to virtual mode, and Mr. B.
All the respondents.
Learned Standing Counsel, Finance and Taxation Department for all the respondents. Full stop. Agreed by inaction on the part of the respondent authorities in not responding, stroke post processing, stroke sanctioning, refund claims, claim to be due to the petitioner for the financial years 1993-1994, 1995-1996 and 1998-1999, the petitioner has preferred the instant litigation. Issue notice returnable in 4 weeks. As Mr. Gogoi has appeared and accepted notice on behalf of all the respondents, no formal notice is necessary. The petitioner, counsel for the petitioner serve requisite number of extra copies of the petition to Mr. Gogoi and standing of the students within 3 working days from today. Who is your assisting counsel here?
Lordships, Mr.
Why you are sitting there then?
Is there, my lords, in court?
Assisted by Mr. GK, the learned counsel for the petition. Okay.
Grateful, my lords, we are obliged. Grateful.
Item number 8.
May I please, lordship? Maternity lordship, ex gratia lordship.
Ex gratia.
Yes, lordship.
You are your husband?
Yes, lordship, my husband.
This is Pathakar. Accident date 22/11/2015. Any representation?
Representation lordship, page number 26, lordship. 26, lordship. Page number.
Page 26.
26, lordship.
Representation Deputy Commissioner, page 26, 20/03/2020. Your name?
AK Das, lordship.
AK Das. A Bhattacharya, Revenue 1. BU S. Borua. Finance? MS?
RM Borwal.
RM Borua. Learned Counsel representing Mr. A. Chaliha. Standing Counsel Finance 2. S. Borua. Junior Government Advocate, Assam. for the respondent number 34567. 4 weeks returnable.
Item number 9.
May I please, Your Lordship, matter pertinent to SBIC, Your Lordship. Her petitioner is the wife of the deceased who had died on 0502/2022.
SI account.
And
Petitioner A Bottasai G Revenue 1 RM Borua 2 S Borua Junior Government Advocate Assam 3, 4 and 5. Wife for a disease. Disease Ruhul Amin. Date of accident 5/2/2022. Any representation?
Yes, Lordship, 2808/2020.
Page 27.
Yes, 27. 28/08/2022. Issued notice.
Develop.
10.
May I please, Your Lordship? Matter may be adjourned for the day, Lordship.
Okay, on the prayer of
Also, item
Mr.
15,
Mr.
is Islam.
S. Islam.
Is Islam.
A.S. Islam.
Is Islam.
H. Islam. Land counsel for the petition and the case is passed over for the.
Item 15 also.
Huh?
Item 15 also.
Mr. Who are the respondent? Mr. Bottasai Revenue as Borua 2 and 3 are present. And
15.
15. Same. Petitioners, petitioners. Pass over for the day.
Item number 13.
May please, Your Lordship. Lordship,
Oh,
this
sorry,
is a
so 11.
Huh?
15 to the past. 11.
11.
11.
May I please, Your Lordships. My lord, the petitioner have limited prayer before his honorable court, Lordships. Lordships, he has a plot, Medipatta land, 1 bigha, 1 kotha, 3 lessons, Lordships. And Lordships, part of the area of land, Lordships, is being used by the public, Lordships.
Being
Used by the
Ah.
public
Ah.
by making a road, Lordships, temporary road, Lordships. And accordingly, Lordships, the petitioner has filed an application before the executive magistrate, Mongoldoi, Lordships. It is filed on Lordship 22/22, Lordships. As on now, Lordships,
what is that application? Let us.
page 21, Lordships.
This is not public. It is only one individual.
Lordship, from him, I have purchased the land.
He is only one individual, not public.
Lordships, I have made the party a second party, Lordships. Lordship, from him, I purchased the land, Lordships.
I have read the content at page 22.
Lordships.
I have read. Now what is 107?
Lordships,
my humble prayer, a direction may be issued to the Deputy Commissioner Lordships for dispose of this application Lordships as per the provision of law.
Who has written this OCPS? Who has written this? Yes, Mr. Borua. It is not a case of 107. I don't know. Oh, here. Is it a case of 107?
No,
Tell me.
it's a completely a personal dispute and public tranquility.
One allegation is that man is trying to dispose.
This
This is purely one versus one. Right.
Lordships.
There is no involvement of any state authorities. That if he is trying to dispose or he has dispossessed you, it is purely a case of civil suit.
and that
Secondly, 107.
if there is a possibility of
Ah.
public peace and
Public tranquility, that has been explained by from the definition itself,
yes.
or that has been explained by Supreme Court.
And in fact, if your lordship goes to the application, it has been
I have
made
seen, I have seen.
2020.
Huh? For that I have not seen.
Yes, I could just figure out in the top left-hand side of page 23. It is 22/2020. I hope public peace and tranquility has been settled now.
If it is being disturbed for 3 years, where is that? No,
23, page 23.
page 23, I am trying to,
Even though it is not legible, but still then I could figure out. And just going by the index that he has submitted, that is 22/2020, he has specifically stated.
abusing the process of the court. 23.
Lordships.
Firstly, paragraph রাস্তায় ঘাটে দেখা হলে অশ্লীল ব্যবহার করে। That is one. Second, যিকোনো সময়ত উভয় পক্ষৰ মাজত শান্তি ভংগ হোৱাৰ সম্ভাৱনা আছে। দ্বিতীয় পক্ষৰ বাদে আন কাৰো কোনো স্বত্ব অধিকাৰ নাই। ৰাতি অস্ত্ৰ শস্ত্ৰ লৈ ঘৰৰ আশে পাশে ঘূৰি থকা দেখা পোৱা যায়। All these are 3 years earlier. 3 years earlier. If he is roaming around with ostro, you might not have been survived to institute this retribution after 3 years. Make a fresh application, make a fresh case, make a
Lordships.
application before proper authority. Tell me when this was filed. From page 23, it appears 20/02/2000. When? Where is the statement?
Lordships.
Where is the statement? When this was page prayer itself.
Yes.
20/02/2020. Prayer itself, page 10. Delayed by laches. Prayer, your prayer, page 10.
Prayer Lordships.
Directed for completion of inquiry of his application dated 20/02/2020.
Lordship.
Where is your explanation?
Page 21, Lordship, that is there.
You have yourself stated. Now there is no dispute about that. Page 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13th line.
Lordship.
And also page 7. Petitioner accordingly filed applications before the learned executive magistrate on 20/02/2020. If you are aggrieved by his inaction, you should have filed revision before the revision authority within the limitation period.
Lordship, time to time I have approached before the,
That will not, that does not explain any situation. I'll be closing the door hard. Mr. R. Sharma. Counsel for the petition. Revenue A ভরাচাইছে S. Burwa, Junior Government Advocate, 1. Junior Government Advocate for 2 to 5. 2 to. The case projected in this writ petition, seeking under Article 226 of the seeking to invoke the extraordinary and discretionary jurisdiction under Article 226 of the Constitution of India. First time to equal. First time to equal. That the petitioner is an owner of a plot of land measuring 1 bigha 1 kata 5 lesas, covered by dag number 2347 and Kiraz Miadipatra number 500, situate at Revenue Village Maroi, Mauja Sipaja, District Durham, subject. He purchased the subject lot in the year. After purchase of the subject lot, the name of the petitioner stood mutated in the revenue records in respect of the subject lot. Stating that the petitioner has stated that he has been paying a revenue in respect of the subject plot of land and is in possession of the subject plot. First of para. The petition has contended that an application was filed by him before the executive magistrate, Mongoldoi, on 2010-2020 for drawing up a proceeding under section 107, Code of Criminal Procedure 1973, as there is apprehension of breach of peace and disturbance of public tranquility. On receipt of the said application, it has been stated that on receipt of the said application, the executive magistrate, Mongoldoi, forwarded the said application to the officer in charge, Sipajar Police Station, for causing an inquiry and to submit a report by making endorsement to that effect in the body of the said application. Full stop. Alleging inaction on the part of the respondent authorities thereafter to proceed under the provisions to proceed and complete the inquiry. The petitioner has preferred the instant requisition, seeking inter alia direction to the respondent authorities to complete the inquiry, stated to have been initiated after submission of his application on 20/10/2020. From the from the contents of the application, comma, it can be noticed that an allegation was made therein that it can be noticed that the petitioner had made one private individual as the sole second party therein. And an allegation was made that the second party was trying to dispossess the petitioner from the subject plot. It was stated therein that the said second party was he's a neighbor, was a neighbor of the petitioner, and the petitioner purchased the subject lot only from him in the year right, only from him. Allegations were also made to the effect that the second party used to utter slang words whenever he used to meet the petition. And used to roam around during nights by carrying arms in the vicinity of the subject plot. The petitioner is silent. There is no whisper in the petition as to what steps the petitioner had taken after to 2020. There is, however, a bold plea that the petitioner had approached the executive magistrate Mongoldoy on 18/6/2020, 25/03/2021, 11/11/2021, 6/8/2021, and 14/5/2021 without any kind of supporting documents. And moreover, such statement has been made on the basis of his petitioner's personal knowledge as per the affidavit annexed to the writ petition. It does, the petitioner has approached from the facts averred in the writ petition, from the above facts averred in the writ petition, it clearly transpires that the petitioner has approached this court seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India after elapse of more than 3.5 years from the date of submission of the application on 20/10/2020. Full stop. The if there was alleged inaction on the part of the executive magistrate, the petitioner had adequate efficacious remedy under the provisions of the Code of Criminal Procedure 1973, and the petitioner had chosen not to avail such remedy for a prolonged period of more than 3.5 years. One para hero, one party 107. In the above obtaining fact situation, this court is not persuaded to reach a view that the instant writ petition is the petitioner has made out any case for entertaining the writ petition under Article 226 of the Constitution. Accordingly, the same is dismissed.
Item number 13.
Your Lordship. Lordship, the petitioner herein, your Lordship, the petitioner's land as well as part of his building were taken because of the Assam Mala project, your Lordship.
Assam Mala project for National Highway or something else?
Yes, your Lordship, it is the state highway, maybe, your Lordship. State highway, Hamreng to Tumreng via Nilbagan, Muraja to Hauragat Karkok Road, your Lordship. Your Lordship, estimate was made by
State highway.
Yes, your Lordship. State Highway 19. I mentioned it on page 6, your Lordship.
Page 6.
Yes, your Lordship.
Okay.
Yes, your Lordship.
Hmm.
Your Lordship, thereafter, your Lordship, respondent number 5 has made estimate, and the estimate was submitted to the respondent number 3, your Lordship. Sorry, your Lordship, respondent number 4, your Lordship. And your Lordship will find that on Annexure 2, your Lordship. Annexure 2, page 14-15, your Lordship. In page 15, your Lordship, There is one building, your lordship, which three are the shareholders of that building, your lordship. And they are number, serial number 52, that is the number one in page number 15, Anasuddin, Asaduddin and Altaf Hussain. Altaf Hussain here is in the petitioner, your lordship. So estimate were made of Anasuddin, Asaduddin and Altaf Hussain.
Your is 12,42,000.
Yes, yes,
One five.
Yes, your lordship.
Okay.
Yes, your lordship. Thereafter, your lordship, no notice were issued upon me. I didn't know any development. Only I came to know that Anasuddin and Asaduddin were paid the compensation. I am deprived of the compensation, your lordship. Thereafter, I have made representation before the district commissioner, that's respondent number 2, as well as the circle officer, that is respondent number 4, your lordship. But I have got nothing, your lordship, no response from them, your lordship. Yeah. And I have also filed a RTI application before the respondent number 2 seeking information that what happened with regard to my compensation, your lordship. Nothing has been informed to me, your lordship. So, your lordship, I am before this honorable court, your lordship.
Yes. Hi, Mr. I. Hussain, learned counsel for the petitioner. A voter ID, revenue 1.
Five.
Okay, S. Borua, Junior Government Program Assam, for the respondent number 2, 3, 4, and S. And M. Das, Standing Council. PWD for the respondent number 5. Full stop. In this petition, the petitioner has projected that he is full owner or part owner?
Your lordship, I am the owner of the 350 square meter of the building that has been taken for Assam Mala project.
Okay. Petitioner is a co-owner.
Co-owner, your lordship.
Co-owner of a building to the extent of 350 square feet.
Your lordship,
350
your lordship, the
square
feet to be
is a co-owner of an RCC building standing on a plot of land covered by DAG number 61 and KP Patra number 117, situated at where?
Devasthan Bazaar, your lordship.
Devasthan, Moja, Nomati, Doboka Revenue Circle, Pujai, District Pujai, post. It is the further case of the petitioner that in order to acquire land for construction stroke widening of State Highway 19 from Hamren, Tumpreng via Nilbagan, Murajar to Hauraghat, Karkok Road under the Assam Mala project, the RCC building, where the petitioner is a co-owner, a part of the RCC building, where the petitioner is a co-owner, came to be assessed, has been assessed for acquisition, and the respondent number 5 submitted a statement assessing the compensation to be paid to each of the owners, including the petitioner, of the said RCC building. The petitioner has asserted that the respondent number 5 has assessed a compensation amount of rupees 12,42,515. Full stop.
Your lordship, this is not the entire compensation amount.
Assessed.
Assessment, your lordship.
Full stop. It is the case of the notwithstanding other claims. the petitioner has submitted that, has contended that though other two co-owners of the RCC building have been disbursed the compensation amounts towards acquisition of land and Zirat, the petitioner has not been disbursed any amount towards compensation for his part of the RCC building. When representations submitted by the petitioners before different authorities did not evoke any response, it is stated that the petitioner is constrained to prefer the instant petition, seeking inter alia a direction to the respondent authorities to make payment of compensation amount as entitled under a law for the land and as a co-owner to the petitioner as a co-owner of the land and RCC building which have been acquired for the project. That is your case? Issue notice returnable in 4 weeks as Mr. Motorcycle, Borua and Das. Extra copies to work.
Lordship, I have a rice hotel on the one part of the building, Your Lordship. That is the only source of livelihood. Now the authorities have initiated demolition, Your Lordship. Your Lordship, I have not also received the compensation. If they demolish my building, Your Lordship, it will have, Your Lordship, it will affect my livelihood, Your Lordship. So, Your Lordship.
Whether your building will stand,
Lordship.
tell me. Whether
Yes, Your Lordship.
after demolition of your brother's part,
Lordship.
as per your photograph,
Lordship.
whether your building will stand.
No, Your Lordship, my building
It
has
is
not yet been
observed
touched.
That it is observed that any demolition has been taking place.
No, not has, till now, our building has not been touched, but in the adjacent area, Your Lordship, demolition has started.
It is observed that the respondent authorities prior to undertaking any process for demolishing the RCC building in question should make proper survey as per law. You have to make survey.
That definitely, if at all it has been demolished. But that apart, Lordship, in this matter, I'm afraid we haven't been served with copies. Otherwise, the cause lists haven't reflected on it.
No, Your Lordship, we have served copies without.
Normally, when copies are being served, names are reflected.
Without serving copies, Your Lordship, the matter.
Maybe he has served.
That debate I am not going into. The name of Learned Government Advocate Assam be reflected in the respondent side.
I'll serve extra copies.
Extra quiz you have to keep definitely.
Lordship.
14.
Lordship, may kindly pass over this matter for time being, Lordship. My senior is on legs, Lordship. Time. Oblige.
16.
My lord.
Yes.
My lord. This petition is against order against notice dated notice under 337 of the GMC. My lord. So notice is, my lord, is page number 31, my lord.
It's
Page 31, my lord.
yes.
A notice asking for document was served by letter dated such and such in the name of Vintage Cafe and Restaurant. But in response to the notice, Vivek Agarwala, owner of restaurant, has submitted a reply dated such as which is not satisfactory.
Page 31 you are reading, right?
Page 31, my lord.
Let us read. Where is?
You have carried out erection of an RCC building without adequate setback area in Vintage Cafe and Restaurant at Damayanti Mansion Housing Society. My lord, Damayanti Mansion Housing, that is near just.
Let us read the entire.
Then a notice asking for documents were served by letter dated such as such
in the name of Vintage Cafe and Restaurant, but in response to the notice, Vivek Agarwal, owner of restaurant, has submitted a reply on 18/9/23, which is not satisfactory. Hence, the notice under section 337, 1 and 2 is now prepared in the name of Vintage Cafe and Restaurant at the mentioned housing society. You are therefore directed to demolish and discontinue the undertaken work of erection or re-erection of occupying the setback area of the building at the mentioned housing society, Guwahati, forthwith at your own cost, and to submit report within 7 days as to why unauthorized structures should not be demolished or sealed. If you do not submit any explanation as demanded above, or if the explanation submitted is found unsatisfactory, the Guwahati Municipal Corporation would be free to proceed under section 337(3) and 337(a)(1) of GMC Act to demolish or seal the unauthorized structures as mentioned in schedule. So, my lord, this is the notice, my lord.
Did you respond?
Yes, my lord, we have responded.
Did you respond?
Yes, my lord, we have responded.
What is your response?
My lord, our response is at page number, my lord.
Page?
My lord. At page number 38, my lord.
30.
I have received the above referred notice from Guwahati Municipal Corporation. Surprised to peruse the content. It appears that at the instance of my landlord, Contempt Chakraborty, and his associates, we are willing to demolish my restaurant premises and to close down my business. Apparently, GMC is adopting vindicative attitude against us, since we have approached Honorable Guwahati High Court by filing writ petition number such against illegal action taken by Guwahati GMC by imposing illegal penalty against us at the instance of our landlord, Contempt Chakraborty. In the said writ petition, we have challenged the fine imposed by GMC on 36/23 against us, and we have also paid before the Honorable Court, restraining GMC from disturbing and harassing us. The advocate of the GMC has assured the court that GMC will not interfere with the operation of the restaurant, and it is reflected in order dated 23/8/23 passed by Honorable Guwahati High Court. While the matter is pending before the Honorable High Court, the GMC is taking vindicative attitude against us and is issuing one after another notices against us. So far, we have got 4 notices from GMC on various grounds at the instance of our landlord, Contempt Chakraborty, and his associate, posing themselves as members of the Damayanti apartment. Firstly, GMC has imposed penalty of 1,50,000 against us on 36/23 without giving us any opportunity to show cause. Thereafter, GMC has issued notice on 28/8/23 to us, and in the said notice even asked us to revive trade license of our landlord's erstwhile restaurant, namely Hungry Well. Thereafter, GMC has again issued notice to us on 12/9/23 for asking to submit copy of no objection certificate, approved plan, and occupancy certificate of the apartment, which was constructed long back, even before our birth, that is in the year 1995. The registers are only 24 years old. The issuing officer did not consider that at the relevant time there was no concept of occupancy certificate. In reply against said notice, we have made clear that we did not proceed with any construction of building, and the allegation of Contempt Chakraborty, who is our landlord, are false and verified. Even your inspector has visited our restaurant, and he has also agreed that there was no.
Yes, notice is regarding erection or re-erection of occupying the setback area.
Yes, ma'am.
Of the building.
Yes, ma'am.
Now you have responded that that is you did not undertake any
Yes.
Erection or re-erection of occupying setback area. It was in existence.
Yes.
Prior to your occupation of the restaurant.
Yes, sir.
And it was perhaps by the builder or by the owner.
Yes, sir.
So
Yes.
why, if the owner or the builder has occupied the setback area, he should not be served the copy. They are tenant only. They are tenant.
Whatever has done, man, if Lordship stands to page number 31, nature of unauthorized Lordship.
Huh?
Nature of unauthorized construction, man.
There is paragraph 3. Paragraph 3.
Paragraph no, that's 3, man. Use of building setback. He is using the building setback for business.
Right.
Commercial purpose.
No.
Use of building setback area for commercial purpose of vintage craft and restaurant.
Which one? Which page 31? Which
Page
paragraph?
31, last. You nature of unauthorized. He is using that setback for commercial purpose. That's why the notice has gone to him.
Nature.
Use of building setback for area for commercial purpose. Setback, you have to leave it. You cannot use it for commercial purpose. And what is the reply, my lord? In page 40.
My lord, here, my lord. what is their notice, my lord? My lord, what is their notice? Whereas you have carried out erection of an RCC building without adequate setback in the vintage cafe restaurant of the MT Convention. So starting is you have constructed RCC building.
See,
The notice is contradictory, my lord.
Sharma,
The
the
notice is
substance is to be seen.
Then, my lord,
Maybe not happily worded, ultimately, nature of unauthorized use is uses of building setback area for commercial purpose of interest.
my lord, what type of use, my lord? Whether it is any construction, if any construction is there, they can demolish the construction.
Setback area cannot be used for any commercial
No,
purpose.
no,
What is the setback area? What is the concept of setback area?
Setback area is the area from your land to the starting of the building, erection of the building. That area have to live in. If he's using, if he's not using, he should not have come to the court itself. Let it give demolition.
No.
Would not have any
Conservation.
No.
grievance.
There is right. If you are not using, you have not given it. But what they said,
Then
what they said,
restricts the clearance should strictly above on the setback area.
It's only in the setback area. You should not do business in that setback area. He is doing business. There is no.
You have submitted reply. Let them take their decision.
We'll take a call, my lord. Now,
We'll take a call. It is show cause, and you have submitted a reply.
you have submitted reply. Now,
Let
now
them
they,
take
now they are making
the proceeding to its logical conclusion. You are waiting for their order.
Now, till then, all right.
What are not
Regarding use of setback area, if you are using setback area, definitely we shall discontinue. But regarding demolition, they said we shall demolish. My lord, notice is contradictory. Notice one way they said that they could have issued notice to not to use the setback
Yes,
area.
what you say about
They should have said that you should use it. But they said we should demolish the demolish.
Presently,
Where demolition came?
he is using that particular area for his business purpose. That's why the notice has gone to him.
okay, that you want to say that this is notice is strictly as regards uses of building setback area
Otherwise, he can run his
by
business
the for commercial purpose
by the petition.
by the restaurant, vintage cafe and restaurant.
But yes,
If that is
that they could have issued the notice, but they said we are going with illegal construction, we are going to demolish the construction. What will demolish by them? What will be demolished by them? That is our main grievance. They can demolish anything. That is
last para. If
Yes.
you do not submit any explanation
Proceed
as
with
demanded above,
demolition.
or please read, if the explanation submitted is found unsatisfactory, GMC will be free to proceed under section so and so to demolish or seal the unauthorized construction as mentioned in the schedule. Now it boils down to schedule. Schedule is uses of building setback area.
My lordship will see the reply, page 40.
My lord, schedule.
Last paragraph.
No, again, my
Reference to the
lord,
notice so and so, we hereby state that we have not.
Have you addressed on the point of uses?
That's this part, my lord. We have
We
not
addressed.
undertaken the work of erection of the occupied setback area of the building of domain. If they have not used, they have not constructed, why should there is no cause of action of this case? He should not have come in before the court because let us go and find it out.
There is one thing, if the erection, because it is as per a schedule, right, to demolish or seal the unauthorized construction as mentioned in the schedule. Now, nature of unauthorized, uses of building setback area for commercial purpose of vintage cafe and restaurant. If this notice is only for that purpose, you have addressed the so-called notice, let them take a call.
My lord, then number one.
Restricting to uses of building setback area for commercial purpose of vintage cafe and restaurant.
My lord, where is that, my lord? Nature of construction. Why I am saying that notice is very contradictory. If they said that no, you cannot use the setback.
That will
is
restrict.
clear.
Uses will restrict.
No,
As the notice is uses for building setback area for commercial purpose of vintage cafe and restaurant. That's all.
But prior to that,
That's all.
my lord,
If any demolition is required to be undertaken, then notices should be served to the owner of the.
Beyond that use. Beyond that.
No, owner, owner.
Simple.
My lord, that I am not on that, my lord.
Then
I am not on that.
okay, we'll hear you. Then we'll pass the order today itself.
My lord, only one thing, my lord.
Your reply I have read, page 40.
Only one thing, my lord. I would like to point out to your lordship. Nature of construction. Ground for construction of Winnie Cafe Restaurant, ground floor construction of cafe and restaurant. Ground floor construction of cafe and restaurant. My lord, entire cafe and restaurant is ground floor. So ground floor cafe, ground floor construction of cafe and restaurant. If the ground floor construction of cafe and restaurant is entirely demolished, that is a different thing. So I am saying the notice is conduct. That is our main. Our main concern is that the notice is completely contradictory. So what I am trying to say that, my lord, the notice
So cause notice is not to be a writ petition against the so cause notice is
My
not to be
prior to that, my lord.
entertained. It is a settled position of law.
My lord, prior to it, my lord.
I gave you the opportunity that on this notice should, the act of the respondent should confine to uses of building setback area for commercial purpose of vintage, cafe and restaurant.
That's
Bora has said that this is the only allegation.
if that is, my lord.
Clearly stated there.
Otherwise, I'm not entering. I'm
Right.
on the basis of settled position of law, I'm
Yes.
not entering. Two options.
They should only look
Otherwise,
at the
to a
uses of,
so cause notice, writ petition is not entertainable.
my lord, this is not only so called notice, sir, my lord. What they said, if you submit an explanation demanded or explanation submitted found unsatisfactory, how unsatisfactory, they should give us a opportunity of being heard. They will decide whether it is satisfactory or unsatisfactory. They have to give us an opportunity of being heard.
Okay, they appear?
Yes, that can be done.
Oh.
Personal hearing can be done.
7 days, they
Yes.
appear.
Lordship
Tell me a
will check
date, tell me a date when they will appear.
At 11 a.m. my lord, working day.
Tell me, fix a date, we're fixing a date. Heard. Mr. S. Sharma, learned counsel for the petitioner, and Mr. S. Bora, learned petitioners, and Mr. S. Bora, learned standing counsel,
GMC. Madam,
ZDD,
ZD and GMC.
ZMC,
Yes.
for all the respondents. The writ petition has been instituted under Article 226 of the Constitution of India. To assail a notice bearing number page 31. Notice dated 17/11/2023. Issued under the hand of the respondent number 3. Full stop. In order to appreciate the nature of the challenge, comma, the notice, same notice, the contents of the same notice is extracted herein in its entirety. Mr. Sharma, learned counsel for the petitioners has submitted that the petitioners are neither petitioners were neither the builder nor developer nor the owner of the premises, and as such there cannot be any question of demolishing the erection, demolishing any unauthorized part of the construction. Full stop. The petitioners have taken the premises only on rent from the owner of the premises to run a restaurant, a cafe and restaurant by the name of Vintage Cafe and Restaurant. Full stop. It is the contention of Mr. By referring to the contents of the notice, comma, Mr. Sharma has contended that the show cause notice is vague and ambiguous in as much as by the show cause notice, comma, while the petitioner have been asked to submit explanation as to why the unauthorized construction mentioned in the schedule should not be demolished or sealed. Full stop. In response, comma, Mr. Bora, Land Standing Council, ZDD, GMC, appearing for the respondents, has submitted that the text and tenor of the notice, from the text and tenor of the notice, comma, it is evident that the petitioners have been served with the notice in respect of, quote, uses of building setback area for commercial purpose of vintage cafe and restaurant, unquote. Full stop. He has further submitted that law as regards issuance of interference with a show cause notice is well settled, and since the petitioners have already submitted their reply in response to the notice dated 17/11/2023, comma, the respondent authority would consider the said reply what a show cause notice as regards the uses of building quote unquote for it. In accordance with law. Full stop. I have considered the submissions of the learned counsel for the parties, and have also gone through the contents of the show cause notice, the contents of which have been extracted above. Close the para. It is well settled by a series of decisions of this well settled proposition that ordinarily no writ lies against the charge sheet or show cause notice no, by issuance of a show cause notice, comma, the noticee is asked to respond to the proposed action. Full stop. It is not a case that the authority issuing the show cause notice, that is the GMC, lacks jurisdiction to issue such a show cause notice. Full stop. The show cause notice is under the provisions of section 337 and section 337A of the
337 and 2. This is so close. One not A, my lord. A is different, my lord. 337 1 and 2.
1 and 2.
Of the GMC Act.
1 and 2
Of the GMC Act. 1920.
under section 337. 337.
Well, 337, then 3 will be, it will come 3 or 1 and 2 will be safe. 3 means the demolition.
GMC Act, then GMC Act.
Three is final, my lord.
Three is
Final,
Okay.
final order, my lord.
okay.
37.
337 1
And one and two, my lord.
and 2 of the Guwahati Municipal Corporation Act 1971. And such authority has not been challenged. Huh? Okay. Goal, Kumar. Fair. Full stop. Had it been the case, had it been the case, the writ petitioner would have well within its right to maintain a writ petition and challenge the so-called notice on that ground. And this court in that event could have the occasion to examine the validity and legality of the so-called notice. Full stop. In the absence of any challenge, this court should not embark to examine the issue. Full stop. With the issuance of the so-called notice, the rights and obligations of the parties have not been decided finally. Full stop. The event of issuance of so-called notice is a step towards taking a final decision in a matter by the competent authority. Full stop. A tentative view taken in the process cannot be deemed to be the final view taken in the matter. Full stop. The final view will be dependent upon the response received from the noticee, and if the noticee is able to show sufficient cause as to why no action as contemplated under the notice should be taken, the final view may altogether be different. Full stop. Thus, this court it is for the aforesaid reasons, the the extraordinary and discretionary jurisdiction under Article 226 of the Constitution of India is ordinarily not invoked at the stage of issuance of the so-called notice, because it is only against the final decision, not a tentative view, the power of judicial review is exercisable. The position has been well settled by a catena of decisions 1, 2, 3, 4. Yes. As the Alliance Trading Council, GMC, has submitted that the so-called notice has been served upon the petitioner only to examine, only to take a decision as regards alleged unauthorized, quote, uses of building setback area for commercial purpose of vintage cafe and restaurant, unquote, the final decision will only be taken only on that aspect. So he has submitted that if the setback area is found to be unauthorizedly constructed, then it is the owner of the premises who is to be put on notice. Full stop. In view of as full stop. As the respondent GMC, as the competent authority in the respondent GMC has not reached any final conclusion after receipt.
Whether the final order has been passed, as of that, I don't.
Take a call. Otherwise, I'll give him personal
because of that
opportunity of personal
because it is
hearing.
that so-called notice was filed on 29/11. Quite a long time back. So,
Take a call. Find out. Otherwise, I'm disposing of. If it is not, decision is not taken, then I'll ask him to appear before the
Commissioner.
Commissioner,
GNC.
for personal hearing,
Lord.
say on 27 or 28.
I also, because later on I said that if the order has already been passed, then the difficulty will start.
Then passing,
It will be there, and then,
passing an order without hearing us.
No, that's a different issue.
That is a different thing. That is a different thing.
That's a different
That is the thing.
Ah,
In fact, my lord, this.
Can you take the instruction?
It can be, after some time, I'll get a call on.
Okay. That part I will dictate after that. If no final decision, then you will appear personally,
If fine.
and personal hearing will be afforded. And whatever decision is taken is to be communicated to you so that you can
Still fix it at 2 minutes, then I can get the instruction.
let him
Not.
obtain the instruction.
At two.
Not.
This part I will leave it with you. We'll resume it after 5 minutes. He was there. Yes, where is Mr. Bora?
Well, he was here only, my lord. I'm sorry, my lord. I'm extremely sorry. My lord, the photographs, lordship, on the last page on the recent photograph. Only some aluminum door and 2 windows has been removed, my lord. The other part is still there. That is the recent photograph, my lord, after demolition. And lordship, one vital aspect I missed out, my lord, somehow. If your lordship turns to the schedule of the sale deed,
Yes, to what extent demolition was done?
This is the report, madam.
my lord, for a moment, my lord, lordship, kindly turn to page 20.
Let me look there.
Copy it down.
But we'll see number 3. Area enclosed beyond 70.52 square meter had been removed on 19/12/2020. Beyond that portion, madam, 70.52 square meter.
And after demolition, my lord, there are photographs I have given. There are 3 walls, they are still there. And only an aluminum, my lord.
When can you file a response?
Yeah, I'll file it after 2 weeks.
Status quo.
Lordship,
Lordship,
on the last page, lordship, it's actually clear, my lord. Here, there is a wall, he has bounded it with aluminum sheet, and the other 770 points or square meter has already been consumed by the.
This one?
Right, lordship.
Which one?
That already there is a.
Which part? Which part? That
Right-hand
one
side,
is
right-hand
bed.
side, there is a drawing room, there is a kitchen, bed, and all this. There is 720 square feet has been consumed.
720?
20 square meter has already been consumed, that area which has been allowed in the 6th floor. So, other in the left side, there was a 3-side wall. One side he had covered it, then.
1 minute, slowly. There is a drawing room, bedroom, kitchen.
Kitchen. That's
near the lift.
Near the lift.
Then is it the
that is not that portion demolished. That is the 70.52 square meter.
Okay, this is about that the area on the top floor.
Top floor, 60.
Permitted area.
Permitted area.
Okay, and this construction is left side or
left side?
This side.
Left side.
This side. Okay.
That is
you according to you excess. Extra. Okay.
If that is, my lord, the case.
1 minute,
lordship.
1 minute, I cannot hear both the.
I'm sorry, man. I'm sorry, man.
At the same time.
I'm sorry.
You want to say that there is a left, on the left side, there is the alleged unauthorized construction by the petition. Okay.
There is a lift, my lord. In the lift.
And to what extent it was demolished on 1912?
It had been demolished.
Area beyond, area enclosed beyond has been removed. If according to you it has been removed, then status quo is today.
What's it?
Lordship, what I understand, my lord.
You are not going to be affected now. Whatever is done is done. It cannot be
What I am trying to project-
repaired.
Yes, definitely, my lord. What I am trying to project, after I have shown the photographs to your lordship, only
According to you, this is the situation.
this is the presence, only an aluminium, and above that, there is a water tank. Lordship has perused in the representation also, the petitioner has stated, just below the water tank. The otherwise, that portion is already.
According to them, they have removed.
Yes.
According to them, it is partially removed, only aluminum sheets are removed.
Yes.
Let them respond, file will take a final
Yeah,
call.
till then, my
Let
lord,
us go.
status quo as on.
That's all.
My lord. No.
Third, Mr. T. Chakravarti, Learned Counsel for the petitioner. Mr. S. Borua, Learned Junior Government Advocate, Assam for the respond number 1, and Mr. S. Bora, Learned Standing Counsel, CMD for the respond number 2 and 3. Pursuant to the order dated 19/12/2023, comma, Mr. Chakravarti, Learned Counsel for the petitioner, has submitted that only the portion consisting of aluminum windows,
Window and one, my lord, wall, not exactly wall, my lord, a partition, my lord, kind of.
okay, aluminum windows and a partition have been removed in respect of the alleged unauthorized construction, comma, stated to have been erected by the petitioner. On the other hand, Mr. Bora, by submitting a report, a copy of the report, who has signed it?
This is the town planner, my lord.
Stated to be of the town planner, comma, GMDA, has submitted that area beyond the construction beyond permitted area of 70.552 square meter on the 7th floor,
6th floor, my lord.
6th floor of
Prakritik Nivas.
which block?
Block 2.
Block 2 of the apartment building have been removed on 19/12/2023. In view of such contradictory, no, in view of such stance which appear to be at variance, comma, the respondent GMD authorities shall bring their stance by way of a counter affidavit. Full stop. Mr. Bora, Standing Counsel GMD, has submitted that the counter affidavit can be filed within 2 weeks' time. Full stop. Lays the case on after 2 weeks.
Lordship, in respect of 4 and 5, notice may be issued, my lord. I have made them parties.
Okay. Notice, issue notice returnable on 22, 22, 24, 24, 24, 24/01/2023, 24, 4/24, as Borua, Bora, 1 to 3.
I have
No formal notice.
I appear for only 2 and 3, madam.
Borua 1, 2 and 3 you. No formal notice, extra copies. The petitioner shall take steps for service of notice upon the respondent number
4 and 5, my lord.
4 and 5 by registered post with AD. Within 2 working days, in addition, the petitioner shall dusty,
My lord.
routed to the registry. Compliance affidavit.
My lord, today is my lord dusty may not be because tomorrow that
I'm saying working days,
working day, my lord. Lord, my lord.
which excludes holidays.
My lord.
It will be within 2 weeks.
Lord, my lord.
Full stop. The parties shall maintain status quo. As on today, as regards the alleged unauthorized construction on the 6th floor of block 2 of the apartment of the concerned multi-storied apartment building named Prakritik Nibas till the next date of list.
I'm obliged, my lord. Deeply obliged.
The photographs placed by Mr. Chakraborty and the report placed by Mr. Bora be kept with the case record.
Obliged.
Item number 42.
Yeah, please, madam. Not here, the petitioner had some Miadi land in his name. Lordship will find at page 25.
Miadi land,
Miadi land,
page
my lord.
25.
25, madam. It's the SMS portion.
25. Okay.
Lordship will find Pita Mahmood Ali Nam Namjari Hoy. Mote Oidagot Iman Abdul Kadir Pita Mahmood Ali Sari Kotha Mati Mohammad Hatem Ali Stholot Kazem Mujibur. I am Kitab, my lord.
You are Kasem?
I'm Kitab, my lord.
Huh?
Kitab. First person on the 5th line. Kitab. That Kitab is me, my lord. Now, in my land, if Lordship will come down below at 4, my lord, Lordship will find Upayukta Karyalayar Gusor number RK
Which part?
Sari.
4 or what?
4, my lord.
4.
4.
Okay.
উপায়ুক্ত কাৰ্যালয়ৰ গোচৰ নম্বৰ RK 4 of 2003 ওপৰত অতিৰিক্ত উপায়ুক্ত ৰাজহ মহোদয়ৰ ইমান তাৰিখৰ হুকুম মতে জুৰিয়া মৌজা তিনচুকীয়া কিছামতৰ 193 নম্বৰ ম্যাদ, that is my land, 588 ডাগৰ 588 ডাগৰ 1 বিঘা 3 কঠা 8 লেচা অংশ 1 বিঘা 1 কঠা লেচা মাটি তিনচুকীয়া পূবচতিয়ান বজাৰ নামত চৰকাৰীকৰণ হৈ 627 দাগ হয়. That is, my lord, where?
What is the date? 14?
My lord, this is how we got the certified copy. It is 14 to probably 2003, my lord. 14 to 2003 is what we have tried to find out.
2003?
3, my lord. Now what has happened?
What is the first part? Then okay.
Now, my lord, what has
Your
happened?
Namjari was by DAW.
Yes, my lord.
In 2001.
In 2001, my lord.
Okay.
And lordship will also find at page 25, my lord.
Page 25. We have read 4. DAW. 4.
Barotero order. Page 24.
Page 24 or 25?
24, my lord. 24, my lord. 24, I'm sorry, my lord. Page 24. Sokro Bihar Baro.
Dantiya or Mudhanno? Page 20?
4, my lord.
4.
Page 24.
Okay, 4.
Sokro Bihar Baro 3 2001 হুকুম মতে
Forward Patta, so and so, my lord. So that all comes in. Now, this part of the land, if lordship will find, পাঁচশ আঠাশী 579 590 পাটাদাৰৰ হাতেম পিতা গফুৰ আব্দুল কাছেম মজিবুৰ কিতাব. Lordship will find again the word kitab, my lord. So of all this part, my lord,
নম্বৰ পত্ৰতাৰ হাতেম স্থলত আবুল কাছেম মজিবুল
kitab is again me, my lord. So this Jongse Monsoon.
all these
My lord, we are all brothers.
brothers.
My lord,
Okay.
so this land came to us by inheritance from my father.
Hatem Ali is your father?
Yes,
what? Huh?
Yes.
Hatem Ali is your father?
Yes, madam. So this
নামে জামদারি হই তাকে কি আলীর
these are all parts, my lord, in parts they have all come down. So this was all my inherited land. And lordship to again find at page 25 what I had shown Upayuktor order motere, as per the orders of the Upayuk, my lord, it was given to some market. Now this I never had notice of since 2003, and I have been using that piece of land. In 2023, my lord, when they start to try and evict me, I move an application. I try to move move for certified copies of the order of that particular date of that particular case to find out how it became Sarkari land.
What notice you mean, sir?
Well, lordship will kindly have page 50 for a moment. I'll come to that one. Lordship will have page 50 for a moment.
50?
Page 50. Annexure 4, my lord.
Yes.
Now, my lord, when they started to say that it was a Sarkari land, I tried to apply for certified copies. They were not given to me. Ultimately, I had to move an RTA through an advocate. This is what they tell me. This is signed by the Additional Deputy Commissioner Revenue, Nagaon. He says, with reference to the subject cited above, I am to inform you that on verification of case register, it is seen that no case was registered as RK 4 of 2003.
What is RK?
That lordship will find at page 25,
25?
down below, where it was given to the market. It was made a Sarkari land. Upayukta Karjaloy Gusor number RK 4 of 2003. Now they say that they don't have no case was registered as RK 4 of 2003. My difficulty is now lordship will find at page 53. The superintendent of police is requested by the circle officer with reference to subject cited above. I would like to inform you that on instruction by the Additional Deputy Commissioner Revenue by letter number so and so to carry out eviction drive at Tinsukia Sotian Biweekly Bazaar on 28/12/2023. Now my difficulty is, my lord, that conversion of the Sarkari land to a Sarkari land without notice to me in the year 2003, I have been paying my revenue, my lord, that lordship would find the revenue receipts at page 52. This year also my revenue has been taken, everything has been done. They suddenly want to now come and evict me from the premises.
You are owner of which tag number?
My lord, I had that 193 number.
Huh?
So it was 588, lordship will find at page 25. 588 was converted to 627.
588.
Was converted to 627.
588.
Converted to on page 26. 627 to
588.
Was converted to 627 on the next page, giving it to Tinsukia Pupsotian Bozar Namot Sortai Kron Kurile at page 26. This order does not exist in their records.
So you are concerned with 4, right? 24.
My lord, yes. With 4, my lord.
Not DO. DO is 590 only.
590. 588 is what I'm concerned about.
588.
588 which was concerned. That is Thaw. This 588 part which came to me. Which came to me, my lord.
By Thaw, 588 tag number has been mutated in the name of
all these persons, including me.
Including
me.
Including you.
Now
in place of Hatem Ali.
Hatem Ali.
Your father.
My father. Now at 25, 588 is taken away and made a Sarkari land. Tinsukia Pupsotiane Bozar Namot Sarkari Korn hoy 627 hoy kora hol. This I never had notice of. Now 1612 they say that Sarkari Bazar land, whatever is there, will evict everything from there.
My only praise, my lord, when that order is told to by them to me that it doesn't, that case doesn't exist in their records, I never had an opportunity to go through it. Today, my prayer would be, let them give me the order, let them give me the record by which it was converted into a circle, and I'll have some right against it if I can exercise it today.
Yes,
Till that
Mr.
circle, my lord, why evict me like this?
Mr. Borua.
How to evict me like this, my lord? That is the only prayer.
Hmm?
the face of it, it feels bad.
RTI, when they say there is no record, how could I even go against it? Where is the issue of giving me a notice on it? They say there is no such case on the case register. I don't get to apply a certified copy. 2003, they pass an order like that. 2023, they say I will evict you today without anything.
Heart, Mr. R. Mojumdar. Counsel for the petitioner. A voter size, revenue 1. As Borua, Junior member, Assam, for the respondent number 2, 3, and 4. Where is Panchayat?
Certificate. 52 is a certificate.
Panchayat, have you served copy or not, Panchayat?
Check this one, it was served.
Huh?
My God, it is.
Call. Otherwise, it will go beyond 4 weeks. You have not served, I think. Despite making them party.
Could have been an
Not
offer.
reflected.
I'll just get them. One second.
Yes, Panchayat people are available, otherwise.
Yes.
There's pending council, Panchayat and rural development department. For the respondent number 4 and 5. No, please call his presence. Let us have his presence. It has been projected that a number of parcels of land. So it has been projected on behalf of the petitioner, by relying upon the copy of the Jamabandi, Annexer 1. That petitioner after the date of the death of Hatem Ali, parcels of land, covered by DAG number 588, 589, and 590. Patta number 1 old, 193 new, situated at village
Tinsukia.
Tinchukia, Moja Juria, Rupohi Revenue Circle, District Nagaon. Nagaon or Hujai now?
Nagaon. Some 11, 12, 2000.
S. Doctor, huh? S. Doctor. Training Council. Came to his sons and daughters, including the petitioner, to transfer. Came to transfer in the names of the sons and daughters of Hakim Ali, including the petitioner, pursuant to an order dated 12/3/2021 of the cycle officer, of the jurisdictional cycle officer. The petitioner has asserted that the petitioner has been paying land revenue in respect of the said parcels of land, including the parcel of land covered by DAG number 488 till date. Till date. Also. The petitioner is aggrieved by the letter number RCJ number 406/2023 dated 16/12/2023 within bracket annex 3 of the circle officer Rupohi Revenue Circle, whereby the circle officer Rupohi Revenue Circle has written to the superintendent of police Nagaon to provide sufficient police force to carry out an eviction drive at Tinsukia-Sotion Biweekly Market on 28/12/2023. Full stop. Para. It has been submitted that when the petitioner obtained a copy of the Jamabandi Annexer 1, referred above, it has come to the knowledge of the petitioner that the parcel of land covered by DAG number 588 had been converted to government land by changing the DAG number from 588 to government DAG number 627 pursuant to an order passed in case number RK4 2003 by the Office of the Deputy Commissioner, by the Office of the Jurisdictional Deputy Commissioner, and the relevant entry in the Jamabandi has reflected that a part of the parcel of land, part of the measuring 1 bigha, 1 katha. Or 1 bigha, 1 less. And that has reflected that part of the and that area of the land which has been made government, had been allotted in the name of Insukia Pupsotian market. Full stop. The petitioner has contended that such conversion of that part of original DAG number 588 had been made government, had been converted to government land by government's DAG number 627 behind the back of the petitioner and without putting the petitioner on any kind of notice. When the petitioner obtain information under the Right to Information Act 2005, the Office of the District Commissioner provided its reply dated 5/10/2023, Annexure 4, informed the petitioner that there was no records in the case register maintained by the said office about case number RK 4/2023. Mr. Bhattacharya, Mr. Borua, and Mr. Dutta, representing the respondents, indicated above, have sought time to obtain instructions. Issue notice, returnable February. As appear as Mr. So-and-so, as accepted, no formal notice. Extra copies within 2 working days. Having regard to the projections made in the appropriate manner, this court is of the consider view that the petitioner has made out a privacy case for interim relief. Accordingly, the contemplated eviction drive to be carried out at Tinshukia Sutian, Bayukri Bazaar on 28/12/2023. In respect of the government act number 627, which is stated to be DAG number 588 earlier, shall not be carried out till the returnable date. Only 627.
Yes.
One bigha.
One we এক কথা কোনটো point of this? This one. Obligement.
Lordship may direct the registry to reflect the name of SCP.
The name of the standing council, Panchayat and Rural Development Department be reflected in the respondent side in the call list.
Obligement.
Any motion?
Can we add number 17?
Forest. Both sides should be there. Forest is not there.
For admission, item number 18.
Pleadings are yet to be filed.
Not
No
complete.
affidavits, not completed.
Who is supposed to, Mr. Borua?
It's a promotion dispute between two individuals.
Promotion dispute. Is it so?
But
It is pending since 2019.
Yes, Lordship, what has happened? We challenged the gradation list because
Petition, 1 minute. Elected for appointment. Yeah. You are from unreserved category?
yes, Lordship. Obvious. Yes, Lordship, I am OBC. Impugn gradation is 31.
Okay. Yes, by High Court, I think.
No, Lordship, CGM.
It will be represented by the standing council High Court.
High Court.
Names are shown or not?
Names are shown.
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 Mr. Bormon, you are for High Court.
No, my lord, I am from,
6, respond number 6.
I have no role to play, my lord. A greater resource prepared by the department.
No role. But you are sitting over the petitioner, that is what the case of the petitioner is. Despite your position was below the petitioner in the select list. That is the case of a petitioner. And the case of the petitioner is that he has joined within 15 days. Right? That is the case.
Yes.
Who is Mr. Standing Counsel, High Court? Call, we can direct him to file the affidavit immediately. There is nothing.
Yes. Yes.
Only the response is required. Yes, MS Borua, Judicial Department.
All this on record, Lordship.
Nobody has filed affidavits for 4 years. Only on the issue whether in the select list X and Y. In the select list, both X and Y have figured. X is above Y. Now, as per the select list, all have to join within a period of 15 days.
Yes.
X joined within 15 days, Y also joined within 15 days. But X joined on the 12th day, Y joined on the 10th day. So, what will be the position in the gradation list? That is the issue.
Yes.
Why 4 years? Everybody has taken. Call Mr. Standing Counsel, GHC. Because all these matters are listed before this went. And later on, HK Das or S. Sharma.
HK Das.
S. Sharma is also MS S. Sharma.
Yes.
MS S. Sharma.
Yes.
Please call.
That's the part.
We'll take an undertaking as a last opportunity. We'll take an undertaking. And you are not filing. You do not want to file. Record that.
Item number 19.
Fishery matter, my lord.
Oh, that fishery. You have got it listed before this court.
It was exhaustively hard, my lord.
But not today.
Not today, after the vacation, my lord.
It will be possible. When?
On a hearing day after vacation.
On a hearing day, South Punya Commerce. How to finish later. Commerce. Okay, 23rd. Okay, as count. Petitioner. Who is for the respondents?
M. Setia was for the government.
M. Setia. So, M. Setia can be represented by Borua also. Or as Borua.
Standing counsel is there for fishery department also. I am for deputy commissioner. Respondent number.
Their names are reflected. Okay, as
Yes,
Borua.
Lordship.
Junior Government Advocate Assam for respondent number 4.
4.
6.
4, 6.
Okay. And who is for 7? Okay.
One.
As the learned counsel for the other respondents are found absent today on call, please the case on 23. 23?
But can it be SC fishery may be shown, my lord? Oh, it's shown. It is shown, my lord. It is shown.
23 one. Huh? Who installment right again?
Sorry, I was in court number 2, Your Lordship, on lakes.
Yes.
I am appearing for KBA, Lordship. Lordship. We have put to challenge Your Lordship
an order, your lordship. At page 78, your lordship.
70.
No, not 78, your lordship. It is at page 132, your lordship.
Before reading, tell me what is the substance?
Lordship, substance is like this, your lordship.
Because it is very small
Lordship.
letters.
Lordship, this is a, your lordship, this relates
You
to
are, who are you?
Your lordship, we are some of the candidates who, your lordship, participated in the election process to the director of your lordship Dhupguri Samabay Samiti Limited. Your lordship, what had happened, your lordship, Dhupguri Samabay Samiti Limited, your lordship. Since your lordship, they could not, your lordship, held their annual general meeting and election in time, your lordship. They are the board of directors, your lordship, they was dissolved, your lordship, and it was taken over by the one-man committee, your lordship, by operation of law, your lordship. Now, your lordship, thereafter, your lordship, certain members of the board of directors, your lordship, they filed an application before the Register of Cooperative Societies seeking a permission to participate in the election, your lordship. Now, as per the bylaw of this particular cooperative society, your lordship, if it is dissolved, your lordship, they could not, the board is dissolved for non-holding of the election, your lordship, the members of the board of directors of the earlier committee could not participate in the election, your lordship.
That is a provision of the act or bylaw?
Bylaw. But act says, your lordship, 41(8), your lordship.
Let us see.
Cooperative Societies Act says 41(8).
Which provision?
41(8), your lordship.
41. Okay, 41.
8.
8.
8. Subsection. The directors shall not be eligible for re-election if so specified in the bylaws.
Okay, where is the bylaw?
Lordship,
Part of the case record?
not case record. I have quoted that, your
Where is
lordship.
that quotation?
23 core.
Where is that?
Your lordship may kindly go through this bylaw, your lordship. এখন video see. Bylaw খন আপনি লিখেছেন। 23 core 2.
কাৰ্যকৰী সমিতিৰ কোনো meaning thereby that members of the board of directors of the earlier board is not eligible to contest in the election, but it is basically re-election.
No, re-election. Next. So, your lordship, reading, your lordship, if we read together 41(8), 41(8) and 23 core 2, then your lordship, they are not eligible. In our humble submission, your lordship.
Okay.
Now, your lordship, what had happened thereafter, your lordship, when they were allowed to participate, your lordship, we came before this honorable court. And in the said round of litigation, your lordship, initially, in the meantime, their nominations has been accepted by the returning officer, your lordship. And at that point of time, we came before this honorable court. And when you came before this honorable court, initially, this honorable court was pleased to stay, your lordship, pass an interim order, your lordship, protecting us, saying that no approval will be granted. And then thereafter, your lordship, if your lordship comes to page 89, the final order.
89?
89.
Ah, 89, yes.
89. Your Lordship may kindly come to page 102. The second paragraph, the question as to whether the decision case of so and so would be attracted to the facts and circumstances of the case is a matter that would require deeper examination. However, since the AGM election to the society has already been held, the election of the private respondents, if any, can be called into question by filing individual election petitions, that too if it turns out that any one of several them have actually been elected. It is not in dispute that the election results are yet to be declared. As such, it is not known at this point of time as to whether any of the private respondents have at all been elected. Likewise, it is also not clear if any of the writ petitioners who have participated in the election has been elected. Under the circumstances, it will not be possible for this court to pass a speculative order on the prayer made in the writ petitions. Situated thus, without expressing any further opinion on the merit of the claims and counterclaims of the parties, the respondents are granted liberty to declare the results of AGM election of the society, after take appropriate steps in the matter in accordance with law. The petitioners should also be at liberty to call into question the election of any of the private respondents on the grounds of improper acceptance of their nomination papers, if so advised. If such election petition is filed by the petitioner or any one of them, the same may be decided on merit of the case without being influenced by the impugn order dated 1/9/2023 passed by the Register of Cooperative Societies, Your Lordship. Now, thereafter, Your Lordship, results were declared, Your Lordship.
Who is the election authority?
Your Lordship registered.
Register himself.
Registered.
Okay. And what happened?
We filed a, Your
That
Lordship.
impugn order.
Lordship. Then, Your
What
Lordship.
is the region?
Your Lordship, reason is that, Your Lordship, Your Lordship may kindly, it is seen from the record that the statement of the attendings of the Board of Directors of Dhupguri SS Limited has completed their terms for 5 years in office on 23/6/2023. But the AGM election was not held within the stipulated period of time. Hence, the Zonal Joint Register of Cooperative Society Guwahati by operation of Section 39 dissolved. The Board of Directors of the society and appointed so and so as officer of management of the society under Section 41(6) of the Assam Cooperative Societies Act 2007. It is also seen from the records that Wajida Khatun and 9 others approached the chairman and secretary of the society as well as their assistant registrar of Cooperative Society Nagaon to convene a BOD meeting to discuss about the holding of AGM election of the society, but no action was taken in this regard. Hence, the embargo prescribes under Section 44A will not be applicable to the respondents in the instant case, as the responsibility of convening the meeting upon the secretary of the society merely because the AGM was not convened within statutory period. The Board of Directors cannot be held responsible, and the members of the automatically dissolved BAD are entitled to participate in the next AGM and election. And during the course of hearing, petitioners could not produce an evidence regarding violation of 41(8) of the Assam Cooperative Societies Act, read with clause 23 Core 2 of the bylaws of the society in passing the order dated 1/9/2023 of the Register of the Cooperative Societies. Extra copy আছে? Now, Your Lordship, after passing of the order, Your Lordship, this order, approval of the new Board of Directors was also given by the, that is, Your Lordship, fact I will have to place, Your Lordship.
These are model.
Lordship, they have adopted this, Your Lordship.
Adopted.
Adopted. That there is
By
no
the
dispute,
society.
Lordship, there is no dispute about that, Your Lordship.
So already.
Already
they are
approval was granted, Your Lordship. That fact I will have to place, Your Lordship. And it was dated 16/11/2023, Your Lordship.
16/11.
16/11.
Otherwise, we don't know, bylaws are not enforceable.
But Your Lordship.
Because of 41(8),
Your Lordship.
That issue has to be examined. If it is incorporated there,
Lordship.
otherwise bylaws standing alone
Otherwise not, your lordship.
of no value.
Otherwise not.
But since it has been incorporated in 41 yes, Mr. Talukdar.
My lord, we'll examine the issue, but having regard to, my lord, the irreparable loss or balance of convenience, perhaps at this stage, no interim order is called for.
Otherwise, democratic process.
Since
It has to
your
be
lordship already
tested.
approval is granted, your lordship, I'll.
We'll test the case.
Lordship.
In fact, there is a division bench judgment also.
That I will distinguish, your lordship, why this is our case. Facts
I have looked at, that is page 102, Zahurul Islam W, read appeal number 31 of
2019.
Okay. Heart, Mr. S. Bodhakut. Mr. Learned Counsel for the petitioners. Mr. S. K. Talukdar, Learned Standing Counsel, Cooperation Department for the reference number 1, 2, 3, 4.
1, 2, 3, 4, my lord.
And 6 also.
6 also. my lord.
Yes, who are the Mr.
MK Hussain, lordship.
M.K. Hussain.
MK Hussain, lordship.
M.K.
Lordship.
Learned Counsel for the response number
8 and 9.
8 and 9.
Lordship.
Stroke aviators.
Capital.
Rest, your lordship.
Steps. Okay.
Register.
The petitioners, as shareholders of Messrs. Rupaguri Homobai Committee Limited, Nagaon, a society registered under the provisions of the Assam Cooperative Societies Act, 2007, Act 2007, had contested in an election to the board of directors of the society held on
17/9/2020.
17/9/2023. Full stop. The respondent number 7216
Lordship.
had also contested for the board of directors by filing their nomination papers. Full stop. An objection was raised on behalf of the petitioners to the effect that the respondent number 7 to 16 were ineligible to submit nomination papers as they, as members of the earlier board of directors of the society, failed to hold the annual general meeting and election within the prescribed time period. Within the time period prescribed by the provisions of the Act 2007. Mr. Bodhakur, Learned Counsel for the petitioner, by drawing attention to the provisions of subsection 1 of section 41 of the Act 2007 and bylaw number 23
for 2
of the bylaws of the society, has submitted that failure on the part of the respondent number 7 to 16 as directors in the earlier board of directors, failures on the part of us to hold the AGM and stroke election within the prescribed time period as directors of the earlier board of directors entailed had made them ineligible for re-election in the subsequent election to the board of directors of the society. Para Mr. Talukdar and Mr. Hussain appearing for the respective respondents have submitted that the after conduct of the election, the elected board of directors are discharging their duties after necessary approval was accorded by the state, by the ARCS, right? Or by the competent authority. Who has thus the petitioners have assailed the impugn order, assailed an order dated 16/11/2023 passed by the Registrar of Cooperative Societies Assam on the ground that the said provisions law have been clearly ignored by said mandatory provisions of law have been clearly ignored while allowing the respondent number 7 to 16 to continue as the board of, or as directors in the present board of directors of the society. The matter would require further examination. First, issue notice returnable on 5-2. The as so and so appeared, accepted, no formal notice. The petitioner shall take steps for service of notice. Extra copy. Number kita saya pilih dikit. Jika dapat puri. By registered post with AD within 3 working days. Observe anything. The legality and validity of the order dated 16/11/2023 and eligibility or otherwise of the respondent number 7 to 16 to continue as the board of directors in the society are made subject to the outcome of the election.
Yes, just inform me.
Last line to KSL. He has further submitted that the proceedings initiated by the show cause notice dated 17/11/2023 has not been brought, has not reached conclusion, has not been brought to conclusion in the form of a speaking order till date. Full stop. But having regard to the fact situation obtained in the case, this court is of the considered view that apart from the written, apart from the reply submitted in response to the so-called notice, the petitioners should also be afforded an opportunity of personal hearing to represent their case before the authority, before passing any final decision on the subject. Full stop. In response, Mr. Bora, standing counsel GMC has submitted that such opportunity of partial hearing can be given to the petitioners on 27/11/2023.
11 AM.
27
27, 12,
December.
23
27/12/2023.
at 11 AM.
Full stop. Having regard to the same comma, it is observed that the petitioners shall appear. And the matter is being dealt with. The matter is being dealt with by the Commissioner GMC, right?
Yes.
So, having regard to the same comma, it is observed that the petitioners shall appear before the Commissioner GMC at 11
AM
on 27/12/2023 at his office. Full stop. Correct.
My lord, after hearing, my lord, after hearing whatever order is passed, that has to be intimated to us. So that if we can
After
approach the
completion of such hearing, the Commissioner, GMC shall bring the proceedings initiated by the show cause notice dated 17/11/2023 to its conclusion in the form of a speaking order. Full stop. The speaking order to be passed, shall be communicated to the petitioners. Petition number one. Petition number one immediately thereafter, as in the event that this final decision is against the petitioners, the petitioners are likely to be visited with adverse consequences. So stop. The petitioners, it is observed that the petitioner should be at liberty to avail appropriate remedy if there is any cause of grievance against the speaking order to be passed by the Commissioner GMC as permissible under the law. Full stop. It is further made clear that the proceedings initiated by the show cause notice dated 17/11/2023 shall confine to the subject of alleged violation, that is, quote unquote, uses of building setback area for commercial purpose of Fintes Cafe and Restaurant. This order disposes of the repeat. Yes. Yes, Mr. Das.
Item number 39.
What's it with regard to original records? We could not find out with regard to more time.
Well, why I doubt. I seen a notification in the government on 4/9/2020 was a COVID time. We got a notification, 50% containment zone and some of the areas were closed itself. So I doubt because they have not acknowledged and received.
Then
I have
maybe on a hearing date on 4th of January, but no coercive action.
Yes, sir.
Only I am deeply obliged that your lordship, I was not going to, your lordship has gone to that portion which your lordship has pointed out.
And there shall not be any coercive action till then. 4th of January.
4th of January.
Not,
It will be, I think, Thursday.
yes, sir. By that time.
No, no problem.
Shall we observe?
Up me right. That will
Huh?
be good.
Okay. Heard Mr. Didas, Senior Counsel, assisted by Mr. A. Talukdar, Learned Counsel for the petition, Mr. S.C. Kyle, Standing Counsel GST for the husband number 1 and 3. So Mr. Ashika, Mr. Kyle, Standing Counsel GST has sought for some time to go through the original record and to produce the same if necessary. List the case on 4/1/2024. Full stop. Till the next date of listing, there shall not be any coercive action. Pursuant to the order in appeal dated 21/9/2023.
Lots.
Deeply obliged.
Being item number 7.
List the case for question or further hearing.
Deeply obliged.
For further hearing.
17.
I seek apology, my lords. I was facing grilling in court too.
Okay.
May I please, your lordship? My lordship, the petitioners are Tangia Forest villagers.
What is Tangia?
My lord, paragraph 2 I have written, my lord, the system, my lordship.
Which paragraph?
Yes, my lordship. Now written. Paragraph 3, my lordship.
Paragraph 3.
Yes, my lord. Tangia is a system whereby villagers and sometimes forest plantation workers are given the right to cultivate agricultural crops during the early stages of forest plantation establishment. Tang means hill and ya means cultivation. It is a Burmese word coined in Burma in 1950. The system was introduced in India in the year 1890.
Now, what relief you want in this petition?
My lordship, our our case is that, my lordship, kindly see the annexure, page 41 may be seen, my lord. My lord, authority allowed us to cultivate land, my lordship.
Were evicted from reserve forest and territories, but since they had no other place to go against, and they entered into reserve forest. I have, by my strength, so dated strength, so instructed the commissioner to stay in reserve as Tangia villages. Don't know what action had been taken in the connection by the district. No report was received by me in charge of this, but it is learned from the bearer of this letter that they have been again evicted on 7th. The land which had been cultivated was already cleared by these encroachers years back, and there are no tree growth in that land. And they make fit for cultivation. The case of the visitors should be allowed to settle. Yes.
Yes, my lord. Now page 47 may be seen, my lordship. Forty-seven is the typed copy, my lordship.
Yes.
Our plea is that, my lordship, we have been living in the forest village since many years ago, my lordship. And we have been paying tax also, my lordship. I have annexed the tax receipts also, my lordship. We are workers, my lordship, of the forest, my lordship. We have worked under the forest. I have annexed the tax receipt and even the workers' detail labor sheets, my lordship, page 300, my lordship. Page 300 is the labor sheets, my lordship. Our staying in the forest is not detrimental to the forest, is because we are working in the forest, my lordship. Page 300.
Now, in this petition, what you are claiming?
Our
Settlement?
claim is that our
Settlement.
My lord, our main claim is that our rights under Forest Rights Act, my lordship, our recognition and verification process should be completed. We will submit all the documents, my lordship, these sheets, receipts, and the tax receipts, all things we will submit before the authorities, my lordship. And till recognition and verification, my lordship, we should not be evicted, my lordship, and let them decide our fate, my lordship.
Did you submit any application?
My lordship, in paragraph, my lordship, para 23 may be seen, my lordship.
Page.
Para 23, page 31, my lordship. For land settlement, my lordship, our ancestors have filed several petitions, my lordship. But for settlements of these forest rights, my lordship, no forest rights committee has been created. And so we could not file, my lordship. Let the verification and recognition, let them allow to submit, us to submit the application, my lordship.
Is there any action apprehended?
Yes, my lordship. I have stated, my lordship, in paragraph 16, my lordship.
What action you have seen from the forest side?
They have marked our house, my lordship.
Huh?
They have marked our house for eviction. There is a paragraph 16. I have said. Recently, some officials of Forest Department have marked houses of the petitioners by informing that eviction drive would be conducted very shortly. The petitioners have not received any eviction notice, but they are in apprehension that they may be forcibly evicted with their dependents. The petitioners, as such, aggrieved, my lordship.
Sir, I have written instructions. There's no such, my lords, as canvas, my lord. There's no such drive to be conducted, my lords. Written instruction
That-
yesterday, my
Good
lords.
if they don't
Yesterday.
evict us, then it is very good, my lordship. We are very fortunate, my lordship.
Just one line, my lord. And this is a reserve forest of
We'll
1848.
keep this on record.
Yes, my lordship.
We'll keep this on
Yes, my
record.
lordship.
However, my lords, these rules, my lord, under which they are established, these rules don't create any heritable right. That also be kept on record. And if, my lords, the point number 6 on the next page, my lord.
We are working, we are their laborers.
Their cases are to be considered as per these rules.
Yes, my lord.
No, heritable.
Would be considered as per these rules.
No. This has created the creation of Tangia villages under this. And this says there's no heritable right. That's
Heard Mr. S.B. Loskor. Learned counsel for the petitioners. Mr. D. Gugui, standing counsel, Environment Forest Department for the respondent number 1 to 5. And Mr. S. Bolwa, learned junior government advocate Assam for the respondent number 6. Full stop. By presenting this writ petition, the petitioners, 62 in number, have projected that they are landless forest dwellers and those forest dwellers. The predecessors, it has been stated that the predecessors of the petitioners were allowed to stay in Dholsera Extension Forest Village within Matijuri Forest Range, Hailakandi Forest Division. In the in 1970s, 1970S, as Tangia, TAUNGIYA, Tangia Forest Villagers in terms of a letter dated 4/3/1976 of the Chief Conservator of Forest, Assam, Annexure 3. It is the further case of the petitioner that since then, since after being allowed to settle as Tangia Forest villagers, the petitioners have been, the families of the petitioners have been residing in the said village till date. Full stop. The petitioners have stated that they have submitted applications before the respondent authorities to consider their case for settlement after conducting recognition and verification procedure for settlement in terms of the provisions of the scheduled tribe and other traditional forest dwellers within bracket recognition of forest rights within bracket close Act 2006. The counsel for the petitioners have contended that while, on one side, the petitioner's application for settlement are not given due consideration. But on the other side, there is a move contemplated by the respondent authorities for eviction of the petitioner from the said village. Mr. Gogoi, Alan as Standing Council Forest has submitted that he has received an instruction from the Divisional Forest Officer, Hailakandi Division, within bracket the respondent number 4, in the form of a written instruction bearing number so and so dated 20/12/2023, which goes to show that there is no move contemplated for eviction or encroachment at Thola Chera extension forest areas at present. Full stop. He has, however, he has further contended that the rules for the establishment and control of forest villages framed under the provisions of Assam Forest Regulation 1891, as amended, do not give any heritable right to persons like the petitioners herein to be settled in any forest village. Issue notice returnable on as so and so appeared, accepted Gogo and Borua, no formal notice, extra copies by tomorrow. In view of the instructions placed, the instruction of the respondent number 4 placed by letter number so and so dated 12/20/2023 is placed on record.
Well, another aspect is there, that marking issue. But what would happen, sometimes they, many times, they go beyond this allotted area. That is the issue.
We are workers, my lords, of the forest department.
That's a different issue.
They
go beyond the allotted area.
Allotment is up to maximum, I think, 10 vega or 7 vega.
5 is my lord.
5.
5. Yes.
If you go beyond that, you are liable to be evicted. Otherwise, even if you are a genuine forest villager.
We are their people, my lord. They are workers, my lord.
Since DFO is placing an instruction, there is no move contemplated for eviction. Let it be like this.
Yes, my lord.
Obliged, my lord.
Deeply obliged, my lord.
Production list item number 1 for motion.
May I please, Your Lordship? My lord, the petitioners herein are the owners of 3 bigha 3 cutters of land in North Guwahati. Originally, my lord, 2 bigha 15 lesses, 2 bigha 5 lesses of 2 cutter 5 lesses land were acquired for the construction of the bridge over Brahmaputra from Guwahati to North Guwahati from his 3 bigha 3 cutters of land.
Out of 3 bigha 3 kata,
3
2 bigha.
2 kata 5 lesser.
So what remained?
Remained 2 bigha 15 lesser remained.
Huh?
No,
3 bigha 3 kata.
3 bigha 3 kata.
Acquired already?
No, acquired or already acquired 2 kata 5 lesser.
2 kata 5 lessa, meaning there were 3.
2 bigha 15 lessers.
3 bigha. No. 3 bigha 3 kata.
Yes.
You minus
2 kata
2 kata.
5 lesser.
So 3 bigha some lesser kata.
2 bigha 15 lessers.
Huh?
2 bigha 15 lessers.
2 bigha 15 lesser?
Remain.
Remain. How can it be? 3 bigha 3 kata.
3 bigha 3 kata.
You are the owner.
Yes.
How much was acquired or sought to be acquired?
It was sought to be acquired 2 kata 5 lessers.
So this 2 kata 5 bigha will be out of 3
Out of
katas.
3 yes.
2 bigha is lesser than 3 bigha, 3 kata.
Yes. So 3 bigha, near about 3 bigha remained, and out of this 3 bigha remaining plot of land, again they requisition 9.5 lessers of land. But the notice which was issued on 28th of April, page 39.
This is acquired for what purpose?
This is requisition for the purpose of installation of shifted AEGSL high tension tower out of ROW under the.
This is for right of way.
Right of way.
Not acquisition.
This is requisition.
No, not a requisition also. This is right of way.
My lord, may I kindly see.
If page 39 is the page 39.
Page 39.
This is right of way.
My lord, may I?
Neither requisition nor acquisition.
May I just read the second paragraph?
Read the first paragraph.
Whereas the land described in the schedule hereto annexed is necessary to be requisitioned based on the requisition made by the executive engineer PWRD, Assam Brahmaputra Bridge Construction Division, Fatasilambari, should be requisitioned for providing land for installation of shifted AEGCL high tension tower out of right of way under North Guwahati Revenue Circle. Now, therefore, in exercise of powers conferred by the second proviso of section 3(1) of the Assam Land Requisition and Acquisition Act 1964, I hereby call upon you, being the person interested in the said land, to make representation in writing within 15 days of the date of service of the notice why the said land should not be requisitioned. And my land is at serial number 2. Dag number 293 of KP Patta number 55. 9.5 letter was required to be requisitioned. Now, this notice was never served upon me.
That name is not reflected.
My name is also not reflected.
Okay, 16 others.
16 others, but my name is also not reflected, and I have not been served with this notice till 23rd of May.
Where is your land document?
Yes, ma'am. The sale date, your lordship will find at page.
So any description in the statement?
Yes, ma'am. Schedule C and Schedule D.
293, Dag number.
293 Dag number. And I have also annexed the
Dag number 293.
Jamabandi.
Dag number 293, area to be requisitioned is 9.5 less.
9.5 less, sir.
Huh.
So total land reflected in the sale deed as well as in the Jamabandi is 3 bigha to 3 kattha, 3 less, 3 kathas. My lord. Now, this note.
This is only part.
This is only
If I see the boundary, eastern boundary is Dag number 293.
Yes.
So only part of that land, 9.5.
9.5.
Out of Dag number 293.
Yes, but the Dag number, this Dag number 293 has a total land measuring 3 bigha, 3 kattha, 12 lesses. Out of this, we have purchased 3 bigha, 3 kattha. Now, is this form A, which is issued under Rule 3 and second proviso of Section 3(1) of Act of 1956, as well as, sorry, 1964, as well as rules, was received by agent on 23rd of May 2023, page 41. While I was undergoing medical treatment for coronary, this CAG operation was done on 25th of May at Chandigarh. Soon thereafter, I have filed a representation as required under the Act and rules. Submitted a representation, which your lordship will find at page 46 on 2nd of June 2023. It was received on 3rd of June 2023. This representation never evoked any response. Rather, they have entered into the entire plot of land and started construction. I have annexed the photographs from page 49 onwards. In the middle of the entire plot of land, they have started construction without going into issuing any order under as required under Rule 4. Form B. And on.
When did it start? This construction activity appears to be much earlier because of the nature, from the nature of construction.
My lord.
This is RCC construction.
This is.
It requires
this is
not 24 hours. It appears that
no,
it
not
has started.
24, not 24 hours.
It has started because see page 52.
Yes.
A well has been complete almost.
My lord, this well is.
It is your plot. This well is inside your plot of land.
This probably this is not well. I think this is a
whatever the nature of construction, see already concrete.
Yes.
Has become concrete.
Yes. And it takes 2-3 days. Your lordship has seen in the this Guwahati club in the middle of the road, the construction was done.
I have seen this nature of construction. It requires time to, what do you say, in cement?
To bond.
Bonding.
Yeah.
Lordship will see
it requires
page
time.
54.
This is under construction.
Under construction.
But this page 50, and if you see page 52 and page 53,
yes,
this lintel or what is the foundation, that has taken shape already.
Yes.
It is not that yesterday they have moved and started constructing.
No, it takes time. Because ultimately the drilling has to go on.
Lordship will see
the piling.
And I think it is for a bridge over river Brahmaputra.
No, my lord, the notice says something else. Form A.
Now, what is the relief you want at this
My
stage?
lord, at this stage, this construction should be staged because they have not.
That is not imminent, that yesterday they had moved in and started construction.
My lord, kindly see page 55. Let me please. Page 55. On 12th of December, they woke up and took up my complaint petition, which was received by them on 3/6/2023, where remained kept in dark whether what has been the fate of our
subject cited.
On 18th of December, a hearing was done, but nothing has been come out. That application representation as required to be disposed of under Rule 4 has not been done yet. Form B has not been issued at all.
No, how much, you stated that some lands were acquired earlier?
Earlier, it was acquired.
Where have you stated?
My lord, in the representation, page 47. Page 48, my lord, sorry. Paragraph 7. Out of our 3 biga 3 kata of land, 2 kata 5 acres of land, as stated here in above, has already been acquired by your good office for construction of bridge over river Brahmaputra, connecting Guwahati to North Guwahati. As such, any more land in the same patta belonging to us, as indicated in your notice dated 24/2023, would cause serious prejudice to us. Since we have already planned to start our business venture over the remaining plot of land, further acquisition of land of 9.5 lesser would again delay.
Your land is bounded.
Yes, but for the purpose of this construction of this of bridge.
Otherwise, well demarcated.
Well demarcated. They have taken 2 kata 5 acres of land from the front side.
That is out of the boundary or within the boundary?
Within the boundary. And they are now constructing in the center of the plot of land. Your lordship will see.
This is for what, tower or what?
We don't know, my lord, because the notice also does not specifically says, and AGCL were also not marked a copy of this notice.
Have you made AGCL party? No.
No, because this Form A is not even marked to AGCL. It is marked to Chief Engineer PWRD EAP.
That notice
Page
is where?
39.
39. When did you receive this notice?
My lord, page 41. 23rd of May 2023, when we went to inquire about our acquisition case. And this, may I just read this rule 3 of 1964?
Assam Acquisition and Requisition Act 1964.
Page 492 of that book.
Awesome.
I will take your lordship to rule 3.
You want the rules? Rules. Next volume to rules. 400?
My lord, it's not the same book.
Okay. Rule 3, okay.
Rule 3, manner of submission of representation by the interested person when land is necessary to be requisitioned for landless or displaced person. Where it is necessary for requisition of any land for landless or displaced person, the person interested in the land shall be informed by the intention of requisitioning his land, and such person may make written representation, if any, against it within 15 days from the date of receipt of such information.
Which part? Proviso you are reading or what? Rule 3.
Rule 3.
Sub-rule 1.
Yes.
It starts with save as provided in subsection.
Assam Land Requisition and Acquisition Rules 1964.
64. Okay, 64. Yes.
Rule 3 says manner of submission of representation by interested person when land is necessary for requisition for landless or displaced person. Where it is necessary to requisition any land or landless or displaced person, the person interested in the land shall be informed of the intention of requisition his land, and such person may make written representation, if any, against it within 15 days from the date of receipt of such information. The information shall be in the form of a notice in Form A. I have referred page 39, Form A. Such representation, when received, shall be disposed of by the state government or the person authorized to requisition and the land, as the case may be, after due consideration, if necessary, by local inquiry by an officer not below the rank of a sub-deputy collector. Now, Rule 4 says an order of requisition under Section 3(1) shall be in Form B, as far as may be, with such modification, if any, as may be necessary. So here, only after issuing Form A, they entered into possession and started construction without issuing Form B. Your lordship will find the next page, probably the forms are given.
Mr. Burwa, take your instruction tomorrow. Because
Lordship, may I take your lordship to one point that has caught my attention? It is with regard to that Form A, that information which has been disseminated to the petitioner. So this Form A has this information, the purpose of requisition has been made very clear in the paragraph 1, of shifting AEGCL high tension tower out of row under North Guwahati Revenue.
you have made mixture of every provisions of law. Paragraph 1 and paragraph 2 do not go together. If it is right of way, it is right of way. If it is requisition, it is requisition. Right of way is a different concept. Requisition is a different concept. Such acquisition is a different concept. You have made mixture of everything.
Maybe wrong connotation of the words.
An
In fact,
officer of collector's nature.
What I wanted to
Mixing
draw here-
everything.
Yes,
In a
Lordship.
notice.
Yes, Lordship. In fact, Assam land requisition, this provision that's already Lordship has gone through.
Otherwise, this right of user, if it is for the purpose of AGCL, it should be under Electricity Act and Telegraph Act, 1910. I think I have today read in the newspaper that Telegraph Act is going to be replaced or repealed. Otherwise, there is a separate procedure for right of way.
Right of way.
For right of way, provisions of this 1964 Act for requisition cannot be applied. Requisition, you get the possession.
Right of way.
Acquisition, it is already, apart from possession, it vests.
The right.
Right of way is only to use that particular, but land remain vested with the owner.
It's a easement.
That line will go above it, so he will get compensation in terms of that. And if he is aggrieved, there is a provision for authority, principal court of civil jurisdiction to seeking enhancement of compensation, etc. I mean, you are mixing everything.
But that apart, I wanted to take your lordship to this provision, Rule 3. So Rule 3 makes it very clear that after getting the information, the aggrieved party, if at all they want to make a representation, they have to make it within 15 days. Now, this notice has been served upon him on 24/2023. And he has made the representation on 2/6/2023. Lordship can make out the difference of dates that he has consumed in the meantime.
15 days within?
No.
Page 41, kindly see.
Within 15 days.
Page 41, we have received.
There is no doubt about 15 days. From 23rd May to 3rd of June.
So this is that point I have to clear whether notice has been properly
Yes,
served.
46.
Yes.
There is a signature also. I don't know.
No, that he has received under protest. That's 41 please.
No, that page 41 is different. Yes, 41 is the representation. No. Page 46 is the representation.
Yes. 41 is the receipt, date of receipt.
Received.
Get the instruction, why he have made everything together. If it is right of way, there has to be proper assessment, prior proper assessment.
Yes. Because right of way.
If it is requisition of only 9.5 lesser, then only 9.5 lesser is to be identified. Since he has more than 3 bighas. And it cannot be the way that you acquire, requisition the land in the middle of his plot without requisitioning.
Figure 5 lessers left. So in fact, I have to
Ask
be
him
specific
what
whether
he intends to do.
whether
the
it is a
collector.
right of way or it is. way.
Yes, and what he intends to do with this kind of notice. Find out. Otherwise, considering that it is a project related to infrastructure.
We are not
also,
objecting. We are not.
So putting a stay will delay a public project.
The entire plot of land is digged. I am also.
Putting a stay will delay a public project.
No,
And
what?
the, cost overrun will be in crores.
It will be doubling.
Right. That is why.
Already the two projects, so simultaneously
Exigency of the situation makes you to get the instruction and place it tomorrow. Let's see.
I will try my level best because time period.
Make an effort.
Yes, I will make an
Because
effort.
otherwise putting a stay is another proposition.
But the entire land.
Then we may ask for Bengali also from the petitioner. If it turns out to be and you have to
compensate.
My lord. We are not objecting. We are not objecting any requisition process or acquisition process. Already we have given two.
No, there at least that power
We have not
is.
even received that acquisition compensation. Apart from that, now.
That is why I have asked that whether this is well bounded.
Yes, it is well bounded.
So boundary wall should not be demolished.
Boundary wall was already demolished during the process of acquisition, the front boundary. Because the
pillar.
Whatever, otherwise, other 3 sides are available.
3 sides are available.
So
they made a.
One can find out what are the actual boundaries.
Yes.
The demarcated area can definitely be traced out.
Then the boundary walls, the remaining boundary walls should not be demolished. So that your compensation, claim for compensation can be correctly assessed. I think that will protect your interest because otherwise power to require or power to acquire or power to exercise right of way, those are available with the state.
By following the due
As an
process of
eminent
law.
body, yes, that can be examined, but ultimate is that money
compensation
amount.
My lord, we are not for money, but if the entire plot of land is digged, then the plot of land will be useless, my lord.
Right. So
In the
in
middle.
the middle of the land, if it is constructed, if the other parts of land are rendered useless.
Yes, madam.
I think that can be claimed. Maybe not at the very moment itself.
Madam, that is
right. And if it is acquired, well and good. Or otherwise, if the right of way is there,
then
ultimately after construction only tower will remain.
Yes. Yes.
And the right of way below it
that will
be
restricted,
compensated.
Yes.
But there may be side effects also. Both sides
exactly.
may be rendered useless or would be dangerous. That possibility is there.
Yes.
But we cannot also seeing
from the notice,
nature of the project, it is also difficult to put a
exactly.
stay.
No, we are not objecting. But the manner in
I'll
which
record that only front side of the boundary wall has already been demolished, but the remaining the boundary walls on the 3 sides
are there and
are in existence.
Existent, and they have broken one side and page 50. You will see one side for construction of.
So respondents shall not disturb the remaining boundary walls as on today. I think that will be the only possible.
No, sir,
You go on constructing.
If at all a massive construction work is going on, so can there be an assurance that the boundary will be intact? because the Brahmaputra pillars are there, the tower is coming up. So that will be a.
This is not pillar of Brahmaputra
No.
bridge.
No, one part. One part has been gone.
Those are not for constructing a bridge side areas. Then you get the instruction.
I
Tomorrow.
will have my specification. Specify.
For the petitioner.
Yes.
Okay. For the petitioner has assailed, has heard Mr. Swayamsa and Mr. S. Burwa, and its junior government advocate. Okay, revenue A for site. 1, Burwa 2 and 3, PWD, PWD. Okay. The petitioners have referred the petition to contend that after serving a notice under Rule 3 of the Assam Land Requisition and Acquisition Act 1964, no order under Section 4 or Rule 4. Rule 4. Okay, rules. No order under Rule 4 of the Assam Land Requisition Acquisition Rules 1964 has been served upon the petitioner despite submission of representation in response to the notice within the stipulated time period of 15 days. Full stop. It is the contention of the petitioners that without serving any copy of the order to be passed under Rule 4, the respondent authorities have proceeded with the construction works by making constructions in the plot of land, in the middle part of the plot of land of the petitioners measuring 3 bighas, 3 kathas.
Yes.
Covered by DAG number 293. Full stop. From Form A, notice within bracket Annex 3, stated to have been issued under Rule 3. And the second proviso to Section 3(1) of the Assam Land Requisition and Acquisition Act, 1964. It is noticed that the land has been sought to be requisitions for providing land for installation of shifted AGCL high tension tower out of right of way under North Guwahati Revenue Cycle. On the other hand, the power has been exercised under the provisions of the Assam Land Requisition and Acquisition Act 1964. Full stop. Place the case tomorrow in order to enable Mr. Borwal and a junior government advocate Assam to obtain the instructions as as to why they are utilizing more than 9.5 lessons.
Yes, entire
remaining land.
As to why the respondent authorities are utilizing areas of land more than 9.5 acres as indicated in the notice Annex 3 and as alleged by the petitioners. Find out a copy, extra copy, or shall furnish a copy of the petition to Mr. Purva.
Lordship, here we have to be specific as regard the purpose of. I didn't.
Purpose, then middle of the lot of land and without passing any order. If you can show that yes, on and in the inside the file, at least some kind of order has been passed. You maybe there may be various reasons for not serving the copy. That is a defined issue.
Form B.
But whether you have passed an order as required under the law.
Item number 2. Production list item number 2.
What is this?
Lordship, in this case, your lordship, the petitioner has come against the enhancement of rent, your lordship, of their shops by the Shorupothar Municipal Board, your lordship, by a resolution, your lordship, adopted in their meeting, your lordship, that is at page 78, your lordship.
From what rate to what rate?
Lordship, rate, your lordship, the ₹2 per square feet to your lordship, ₹10. And if we calculate annually, your lordship, I have made a statement, your lordship, at page 9, para 6, your lordship, what was the original annual rent and the enhanced rent, your lordship. Page 9, para 6, your lordship. It's around 400% increase, your lordship. These are small shopkeepers, your lordship. And the nature of their shops, I have also mentioned, your lordship, in para 3.
Since when rate were not increased?
2017, your lordship, is the last increase in the land rent.
Last increase. Where is your statement?
Lordship. Para 12, your lordship. Page 15. Now, your lordship, the basic problem with this, your lordship, is that the basis on which this enhancement has been done has not been disclosed, your lordship. Nobody knows. If we go by the section 79, your lordship, which fixes the annual rental value, and that should be the basis on which your lordship rent should be fixed, your lordship. That procedure, your lordship, apparently has not been followed in the
What
present.
is of the Municipal Act?
Municipal Act, your lordship.
Let us see.
If your lordship takes up the
Assam Municipal Act.
lordship. Under section 148, your lordship, they have the power, your lordship, to levy taxes, take rents, your lordship. And the 148 does not disclose, your lordship, how the rents will be, your lordship, what will be the basis of fixing a rent. But section 79, your lordship, apparently, your lordship, determination of annual rental value.
If decided in a meeting, maybe 148.
148. 140 is the power, your lordship. 2. The board, if decided that a meeting may levy rent, toll, fees at such rates it may think proper for the right to expose goods for a sale in municipal market and for the use of shops, stalls and standing therein, and also in respect of parking lots, and may also regulate such rates respect of private market or places used for declaration declared by the board as a marketplace, parking lot by public notice in the locality or what. Now, this is the power, your lordship. There is no, your lordship, the basis on which this will be fixed, your lordship, is not there. But your lordship, if your lordship comes to section 79 of the act,
Yes.
It says, your lordship, about annual value of holding and your lordship of the annual, which will be on the basis of annual rental value. And annual rental value 79(1) has defined as and means the rent that a holding is capable of fetching over a period of time. And there is a procedure laid down, your lordship, for arriving at that annual rental value, your lordship. Publication of notice, your lordship. Now, your lordship, a shop, your lordship, which is in the main road, your lordship, cannot fetch the same value.
This exercise of fixing annual value of
Lordship.
holding
Lordship.
used to be in general.
In general, your lordship, for
Not
holding.
Putting every stallholder into notice.
Lordship.
It is for general.
Lordship.
That we are going to increase the rental value of the municipal area for this location this much, for
Lordship.
this location this
Lord.
much. That can be the exercise,
Lord.
not to individual.
Lordship. But ultimately, your lordship, they have taken a decision, your lordship, that it will be increased from rupees 2 per square feet to 10 per square feet, your lordship. What is the basis that has not been disclosed, your lordship?
How many, where you are running your stalls?
Your lordship. That is called, your lordship, Sorupothar Old Market of the Sorupothar Municipal Board, your lordship.
Old market.
Old market. The old daily market. And it is under ward number 4, your lordship. And your lordship, the nature of business, your lordship will find that para 3, cloth tailoring, cloth business, tea shop, shoe store, and magazine.
Yes, municipal administration, housing urban, have you soft copies or not?
Municipal
Urban,
administration.
House is standing. Yeah. Name had not shown, only GI was written.
We have been told.
Till the next year, you continue to pay in the old rates.
Rate, your lordship.
But with the answer thing that if the writ petition fails,
We will, your lordship. We will have to, your lordship, ultimately. If it fails, your lordship.
ahead, Mr. Asporter. The counsel for the petitioners. And MS Asburo, you can accept notice for whom?
Yes, 8 and 9.
8 and 9.
Yes.
Why not 7?
Oh, yes, 7 also.
7 not. Not 1 to 3.
Municipal Administration Department, there is a standing P. Nayak.
Okay. Asburo and Junior Government Bugrassan for the response number 7, 8, and 9. It has been projected that the petitioners, comma 7 in number, comma, are persons running different businesses like cloth shops, tailoring shops, tea shops, tea stalls, etc. Book stalls, etc. From running their businesses from shops located in the daily market, comma, ward number 4, under the aegis, AEGIS, of the respondent Horupatha Municipal Board. Full stop. According to the petitioners, comma, the last revision of the rent was made in the year 2017-2018 at ₹2 per square feet. Full stop. Where is the notice?
Lordship will get it, your lordship.
Why you have come so late?
Lordship, in fact, we have come before this honorable court earlier, your lordship. That your lordship, some aspects, your lordship may kindly come to page 91. The order of.
Where is the notice?
Notice I am page 27, 28, your lordship. And latest notice, your lordship.
27, 28.
And last notice is at 18/12/2023. Okay, no, that is at page 87. And page 87 is the last notice, your lordship.
That part. Okay, this is, which one is correct? Wrong. Your English translation is wrong. 27. That is the difficulty. That is why I always refer to the vernacular or whatever original is. You said that from
1/4/2023. Sorry, your lordship.
It is nowadays I am finding it very unreliable to refer to the typed copies. The respondent municipal board authorities, by serving notices on various dates, have started demanding rents from the petitioners at ₹10 per square feet. Full stop. Terming such enhancement of rate as exorbitant, the petitioners have preferred the instant writ petition. Full stop. Reliance has been sought to the provisions of the Assam Municipal Act, 1956, to submit that the enhancement of rental rates in such by 400% should be proceeded with an exercise laid down by the statutory provisions, but in the case in hand, the respondent municipal authorities have not undertaken any such exercise. Issue notice returnable in February. As Borua appeared and accepted, notice 789.
I can.
1, 2, 3.
2, 3 for, I can appear.
Okay. 2, 3 लिखिए. The learned counsel for the petitioner shall serve copies of the writ petition to Mr. P. Nayak, learned standing counsel, Urban Affairs, for the respondent number 1 by tomorrow. The petitioner shall take steps for service of notice upon the respondent number 4 and 5, 4, 5, and 6 by registered post with AD. In addition, you take dusty. In view of the projections made on behalf of the petitioners that the such enhancement by 400 times is arbitrary and without following the requisite exercise laid down in Assam Municipal Act 1956, it is provided that till the returnable date, the petitioner shall continue to deposit the rents in respect of their respective shops. First of, it is such interim order is made with the condition that in the event the writ petition fails, the petitioner shall have to deposit the rents at the at rates uh, at rates as required under the law.
At all rates, as.
All rates. At very rates prior to the enhancement.
Timing item number 18.
Yes, cases that for 4 years,
Yes,
no counterfeit is filed.
my lord,
That is why I have called for your appearance,
my lord.
so that we could give a last opportunity.
My lord. Yes, ma'am.
And that last opportunity, as per your choice, 2 weeks or 3 weeks or 4 weeks.
4 weeks, ma'am.
4 weeks. I heard Mr. B.P. Bora, like counsel for the petitioner. We state, Mr. S. Borua, judicial,
Yes, for judicial department.
Junior Government Advocate Assam for the response number 1. Mr. G. Bushaw, Lion Standing Counsel, Guwahati High Court for the response number 2, 3, 4. BTC. Okay. And Mr. N. Borwon, Lion Counsel for the response number 6. The respondents were put on notice as far back as on 22/4/2019. Full stop. A period of more than 4.5 years have elapsed, but none of the respondents has filed any counter affidavit. Full stop. In such facts and circumstances, a last opportunity for 4 weeks is granted to the respondents to file their respective counter evidence, with the observation that in the event no counter evidence is filed on behalf of the respondents, the court may proceed with the writ petition. Court may proceed to decide the writ petition on the basis of the materials available on record.
Before break, respondent number 6 is submitted that they will not file affidavit.
I given last opportunity. All have been given last opportunity. So same will apply to him. Lease the case on.
Item numbers 20 and 21.
Those
Oh, that one.
yes, my equal parity matters.
Parity.
My lord, would your lordship be pleased to fix?
Parity could be possible only in the next year. Not today. I don't think so.
In any case,
Court
Mr.
is anyway rising at 3.
Mr. K.N. Choudhury is leading me in the case.
Tell me in a new year, tell me.
My lord, either 11th or 12th.
Lordship, after vacation.
11, 12 is also not possible. This court will not be available, and this brief is, I think, assigned to this court.
Yes, only this.
11, 12 is also not possible because this court will not be sitting here. It will be sitting here in some other state.
Then, my lord,
Not in Assam.
any
Not within the jurisdiction of Guwahati High Court. On 11 and 12 also. Neither in Mizoram, nor in Nagaland, nor in Arunachal, some other state.
My lord, we got the hints. We got the hint.
So after
My lord,
Republic Day.
my lord, then any date after 10th of February, Mr. Choudhury will be busy with some other.
Okay. 13th?
Yes.
Tuesday.
Yes, lord.
Deeply obliged.
Okay, Mr. Jiabedin. Petitioners. N.K. Korita.
Sharma Lord.
And Sharma. N.K. Sharma. Okay. S. Burwa. One.
Three.
R.M. Burwa.
So finance department.
S. Saliha. Two. 1 and 3. As
I am for 1 and 3.
and Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das. Our standing counsel GST are present. Full stop. As agreed to by the learned counsel for the parties, list the cases on 13 to 2020.
24. Deeply obliged.
Deeply obliged.
Item number 23 and 24.
My lord, 2 weeks time may be allowed. My lord, I could not file additional affidavit.
What was the deliberation on the previous date?
My lord, the government was asked to submit.
You are supposed to
status-
file an
status
additional
report.
affidavit, my lord.
Status report was also.
Because he wanted to give a representation before the deputy commissioner, my lord.
For what?
And earlier application was not as it should have been, my lord.
Well, I forgot, but some deliberation was made. That is why I am asking.
Acquisition matter, my lord.
Land acquisition.
Yes, my lord. So 2 weeks time may be given, a date may be fixed, otherwise it will not come, my lord, because he has interim order, my lord, so because 6 months back it was filed, my lord.
Okay.
Affidavit, my lord.
J.C. Gore, learned counsel for the petitioner, has sought for further 2 weeks time. To file additional pleadings in deference to the order dated 29/11/2023. So, Miss S. Borua, Junior Government Advocate. And who is one? Mr. Bhattacharya, A. Bhattacharya, Revenue 1, S. Borua, Junior Government Advocate, Assam, for respond number 2 and 3. And Mr. Mukhtar, S.K. Mukhtar, counsel for the
4 and 5.
number 4 to 6.
4 to 6.
Mr. H. Chaudhary, same.
We are received, my lord.
Are present. The prayer made by Mr. Gore is allowed. List the case on a date fixed by the office in the week commencing from 22nd January. Any interim order?
Yes,
Be
yes,
extended
yes,
somewhere?
yes,
No, no, in the other cases.
Other, we are not there, my lord.
Any learned counsel sitting inside the court? In any case, interim order is to be extended.
My lord.
Here.
Yeah,
Oh, yeah,
in both the cases, no, interim order.
Extend to you. No, in the other cases. Your interim order is extended. I am asking the other councils. Yes, Mr. Phugon. Any interim order is operating?
No, my lord, my
Yes,
ID is
Mr.
27.
Tiwari. Yes, Mr. Sharma. Then you have to see your cases in the next year. Any urgent matter to be listed on a fixed date?
Then 30 for that matter.
What is the subject?
Contempt case, my lord.
Huh?
Contempt case, my lord, there is a direction to decide the issue within 6 months. But that has already elapsed.
That is not. Some eviction kind of thing is available.
No.
Eviction, demolition. No.
Item number 26.
Eviction, demolition.
Not demarcation malicious, my lord.
Demarcation.
Only representation may be disposed of, my lord. Annexation.
No, not today. It is not possible. Next year, next year.
Lordship, in item number 30, interim order may be
Interim accessory check for it.
30.
30 to 29 out of the 29 or 30. নাই পৰা আহিব ছাৰে না